Welcome to our demonstration of a United States civil jury trial. We very much appreciate your coming. I know the concept of a U.S. jury trial strikes fear and terror in the hearts of lawyers and businessmen outside the U.S., and maybe, in my experience, maybe particularly in Germany for some reason. And we hope, as part of this process, to kind of give you an idea of what a trial actually looks like, what the role of the jury and the lawyers and the judge is, and perhaps maybe make you a little less afraid of the process, and to understand that it's a different way of adducing evidence and presenting arguments and resolving disputes, but it's certainly not an irrational way. I will say that if this were a case, before we got to this point, the opening of a jury trial, the case had probably been pending on average anywhere from 2 years to 6 months, depending upon the jurisdiction and how busy the docket is in that jurisdiction. In some jurisdictions it could be more than 2 years, and some it could be shorter than 6 months to get to trial. But that's probably a rough average estimate of how long it takes to get to trial before you actually present the case to a jury. And during that time, the parties will, in the beginning, resolve the pleadings. There may be motions to dismiss or attacks on the pleadings, the plaintiff's complaint as originally filed. And then the parties will go into what we call the discovery process, which is called in the UK disclosure. And in the US, the discovery and exchange of information is probably far more extensive than it is anywhere outside the US, because it includes not only the exchange of documents, which is just common in many jurisdictions. I know that you don't do that so much here in Germany, but it also includes depositions, where the lawyers have the ability to require principals and witnesses for the other side to come into their office, take an oath, be placed under oath, penalty of perjury, and to ask them questions, and that a court reporter is present and a record is made. The result of this is by the time the parties get to trial, the lawyers and the parties will have should have, if they've done their job, good understanding of what the evidence will be and what the witnesses will testify to. So that's a process, as I say, will have taken 6 months to 2 years for the case to get to trial. Now, I'm going to be playing the role of the judge, and you might wonder, who am I? What's the U.S. judge? What's the judge's background? And in our country, we don't, being a judge is not a separate profession like it is in Germany and in many countries around the world. You're not particularly trained to be a judge. Most of the judges they're lawyers, they will have law degrees, they were in private practice at law firms, they may have been in public service. Many of them will have been government lawyers, prosecutors, public defenders. But the key thing to know is they haven't been trained as judges. They'll have maybe, if you're appointed a judge, you may have a training program that you'll go through for a month or 6 weeks. But it's not in itself a career option. Judges in some states must stand for election periodically. They'll initially be appointed by the governor and confirmed by the legislature, and may have to stand for election periodically. That's in the state judiciary. In the federal system, of course, the president nominates judges, the United States Senate, and when they get around to it, confirms judges. And it's a lifetime appointment. So if you're appointed to be a federal judge, you have that job for life. Federal judges are notoriously and famously very, very independent. So that's kind of the background of what we're going to be doing here. I mean, is there any reason why we should not begin the trial at this point? So the trial is going to begin as it would in any jury trial, in any state in the United States, state system or federal system. It will begin with opening statements by the lawyers, where the lawyers will give the jury kind of a preview of what the evidence will be. So the jurors kind of have a picture of the landscape. And at every step in the process, the plaintiff goes first. So the plaintiff will give an opening statement, then the defense gives an opening statement, and then the plaintiff begins its case. The plaintiff starts to call its witnesses. The plaintiff will call a witness, do what we call a direct examination of that witness, then the defendant will cross-examine the witness. There's potential for redirect and recross. That's usually very limited. And then you go on to the next witness. After the plaintiff has called all their witnesses, the plaintiff, it said, rests the plaintiff's case. And then the defense begins its case. We'll call defense witnesses, do the direct examination of the defense witness, then the plaintiff will cross-examine the defense witnesses, and we'll go that until the defense rests its case. And then the final stage is the lawyers have an opportunity to argue their case to the jury. That is to sum up what the evidence is and how they believe the law should be applied to the case. The jury is going to be instructed by the judge on what the principles of law are. And the lawyers can then, in the closing argument, argue the case, argue what they believe the evidence showed, and how the law applies to that evidence and why their client should get a verdict. So the closing argument is very different than the opening statement. The opening statement should just be a non-argumentative statement of the evidence, and at the end you have the lawyers actually have an opportunity to argue the evidence. During the trial, the lawyers are free to raise objections, which the judge will rule on. There are certain ways that questions must be asked. The judge is kind of the gatekeeper, not only as to the form of questions and how lawyers ask questions and how they deport themselves, but also in terms of what evidence is relevant. And if a party objects to evidence that's being offered, they object, the judge then rules. Objection's either overruled or it's sustained. If it's overruled, the lawyer will go on, the jury will hear the evidence. If it's sustained, the lawyer must move on. The evidence will not come in. So, that is a preview of what we're going to do. And so I'm now going to begin, just like you would in a jury trial in the U.S., and I'm going to call on plaintiff's counsel. Does plaintiff's counsel wish to give an opening statement?
Yes, Your Honor. Thank you, Your Honor. Good afternoon, ladies and gentlemen of the jury. This is a case about broken promises. My name is Manisha Sheth, and it is a privilege and honor for me to represent Cranbrook Industries in this case. Today, you will hear a story about two companies, Cranbrook Industries and Intellex. Cranbrook, you will hear, was a family-owned business that for decades made and sold all sorts of toys and games in the United Kingdom. You will hear from Blair Nichols, the CEO of Cranbrook, and he will tell you how his grandfather started this company from scratch. And after Mr. Nichols got his MBA from Cambridge University, he realized that the family business had to evolve. He had to keep pace with technology and enter the market for toys of the 21st century, video and computer games. And to do that, Cranbrook entered into a contract with an American gaming company called Intellex. And under this contract, Cranbrook was to manufacture and market in Europe video games and game players that used a new computer chip technology called the Smart Plug. This new product allowed games to operate at a faster speed and was a great tool for American-style action games. And under the terms of that contract, Intellex developed the Smart Plug product and technology and licensed to Cranbrook the exclusive right to manufacture and market all Smart Plug products in Europe. Now you will see that contract, and you will see that the contract defined the term smart plug to include not only the smart plug product, but also all other products that were based on or designed to be used with the smart plug chip. And the contract made clear that the term smart plug extended to all modifications, adjustments, and improvements to the smart plug technology. And you're going to hear from Mr. Nichols that it was so important for him to have an exclusive license. But it also had to cover not just smart plug, but also improvements and subsequent products that were built on the smart plug technology. And he was so careful and so committed to this that he wanted to have a belt and braces approach. And so he also required that Cranbrook have a right of first refusal for any new Intellex products. And you're going to hear how he emphasized those two requirements to his lead negotiator on the contract, Ms. Eve Rosenberg. Now you're also going to hear from witnesses from Intellex. And you're going to hear that at the same time that Intellex was discussing this contract with Cranbrook, Intellex was actively developing another product, the SP2 product. And this product was supposed to revolutionize the gaming industry. Not only could it support fast games, it also could support complex, logical, and thinking games. And you're going to hear that the SP2 product was based on smart plug, and it was built off of the smart plug technology. And you're also going to hear that the SP2 product could be used with smart plug games and video consoles. And you're going to hear that the smart plug product could be used with SP2 games and consoles as well. And you're going to hear that in spite of all of this, not a single person at Intellex told Cranbrook, even breathed a word about SP2 to Cranbrook. Indeed, the Intellex CEO, Ken Morganfield, knew that the SP2 product had so much potential that he didn't want to be locked into an agreement with Cranbrook. And he wanted his lead negotiator, Ms. Willa Judson, to make sure that the SP2 product was expressly carved out of the contract. But Ms. Judson did not do that. Instead, she assured Cranbrook that its exclusive license would cover smart plug, any plug, or any other product that Intellex had on the horizon. Nowhere in this licensing agreement is there any mention of an exception or a carve-out for SP2. In 2015, Intellex launched the SP2 product in the United States, and it was a huge success, as they expected. So Intellex decided, let's expand the distribution to Europe. And you're going to hear that when Cranbrook heard about this, its CEO naturally thought, well, we'll have a chance to market this product, either under the exclusive license or under our right of first refusal. But you're going to hear that Intellex did not want Cranbrook to distribute the SP2 product at any cost. And so they took the position that SP2 was a new product as opposed to any improvement on the smart plug product in order to get out of the exclusive license. And worse yet, you're going to hear that despite the knowledge that Cranbrook had a right of first refusal, Intellex secretly orchestrated a proposal with another company, a Dutch company called Contendo, to make sure that Contendo's proposal would be impossible for Cranbrook to accept. First, unbeknownst to Cranbrook, Intellex commenced secret discussions with Contendo to distribute the SP2 product. It then told Contendo about Cranbrook's right of first refusal. And together they came up with a proposal that they knew Cranbrook would not be able to match. You're going to hear that they formulated a proposal that included a requirement for repair facilities in Poland, Hungary, and the Czech Republic, countries where Contendo had offices, but Cranbrook did not. It also included a liquidated damages provision, whereby Contendo would have to pay Intellex $50,000 for each month in which it failed to open up those repair facilities. But that was not it, ladies and gentlemen. You're going to hear that there was a secret side deal, a deal that was not disclosed to Cranbrook, a deal where Contendo offered to simply use its sales facilities in those 3 countries as pickup and drop-off points, and instead actually ship the products that needed to be repaired to a location in The Hague. That deal was not disclosed to Cranbrook. Now you're going to hear that Cranbrook accepted this proposal. And not only did Cranbrook's proposal match Contendo's proposal, but it exceeded its proposal. First, the terms of Cranbrook's proposals increased the percentage of the royalty. So they proposed an 18% royalty in many countries, whereas the Contendo proposal was only 15%. Second, it offered a much faster production timeline. And third, it offered the same thing in terms of matching Contendo services by saying that they would send the repairs to a location in Germany, which was centrally located. But you're going to hear that Intellex rejected this proposal. It said it was a counter-proposal. It said it didn't meet or exceed Contendo's offer. And you're going to hear that to this day, as we sit here in trial today, Contendo has not opened up a single repair facility in Poland, Hungary, or the Czech Republic. And you're going to hear that despite that, Intellex has not even enforced the liquidated damages provisions in the contract. And when they rejected Cranbrook's proposal, they waited until the end of the 30-day period. And then they told Cranbrook that it rejected its proposal, so that when Cranbrook reiterated that it was accepting the proposal with no changes, then Intellex said, sorry, your proposal is untimely, we are rejecting it. And you may also hear that Intellex will tell you Cranbrook didn't meet its end of the bargain. You'll see what the contract requires. It requires that Cranbrook exercise best efforts and that its performance be satisfactory. And you're going to see what it doesn't require. It doesn't require miracles. It doesn't require a specific timeline for achieving sales in Europe. It doesn't even require a particular volume of sales. And you're going to hear that Intellex themselves thought that Cranbrook's performance was satisfactory, and more so, that it was doing an outstanding job of getting the word out in Europe about SmartPlug. So ladies and gentlemen, I ask you today to carefully listen to the witnesses, read the documents that have been submitted into evidence, and after you do so, you will see that the only fair and just verdict in this case is that Intellex breached its obligations to Cranbrook. First, by breaching its obligation to provide an exclusive license, and second, by breaching its obligation to provide Cranbrook with the right of first refusal. Thank you.
Thank you, Ms. Sheth. Mr. Madison, opening statement for the defense.
Good morning, ladies and gentlemen. I want to introduce myself again. My name is Steve Madison, and I'm a lawyer. And in this case, I speak for a company called Intellex. And you can see the name up on the board there. I want to also take this opportunity to introduce you to the two principals from Intellex who are here today. Now, Intellex, as you sort of heard already, is a massively successful American video game company. And it's really due first and foremost to the efforts of Ken Morganfield. Mr. Morganfield, can you stand up, please? Sure. Mr. Morganfield founded the company, and he actually holds the patents on all the technology that we'll be talking about in this case. Thank you. And then with him today is Willa Judson, who is the Executive Vice President and Director of Operations. And she actually negotiated with this company, Cranbrook, from the UK in the matter that we're here for today. Could you stand, please, Ms. Judson? Thank you. You can be seated. Now, Ms. Sheth says that this case is about broken promises, but I'm here to tell you this case is actually about how companies should do business, whether they should work hard, innovate, create, and put their products out to market with all the risk and the reward that that entails, or whether, like Cranbrook, they should fail to perform and then come into court and hope that you'll cut them a break and require us to write a big check. I'll prove to you today that we're right and they're wrong about these claims of breach of contract and about how companies should do business. But first, I want to just show you a couple of things that just aren't even disputed in this case, lest you be confused. First of all, it's not disputed. There's no dispute that SmartPlug and SP2, the two different technologies that you'll hear about, were created and are owned by Intellex, not Cranbrook. Cranbrook is a 100-year-old British toy company. They make wooden hobby horses and tin whistles. They are not a video game company, and you'll hear that when their witnesses testify. Secondly, there's no dispute that Cranbrook, not Intellex, has the burden of proof in this trial. They've come to court and made these claims against Intellex, and they have the burden of persuading you.
Counsel, I think you're arguing the law at this point.
I'll move on, Your Honor. Thank you. And finally, it's not disputed at all that the license agreement at issue here clearly called for marketing and sales throughout Europe, but Cranbrook never sold one unit in almost 1/3 of the continent by population and country. So you'll hear the evidence will show that each of you has sold as many units of these video games as Cranbrook did in 1/3 of the population and the countries in Europe. So let me go back a step and tell you about SmartPlug. SmartPlug was a technology for action-packed video games that was created, invented by Mr. Morganfield. And it took off in the United States, and it was extremely popular and successful. And as you probably know, and incidentally, if any of you has children who spend too much time playing video games, on behalf of Mr. Morganfield, I apologize for that. But as you probably know, these days, gamers, kids and others who play these video games can play with others all over the world using headsets and the internet and the like. And so in 2013, Mr. Morganfield and Intellex decided that they needed to have a presence in Europe, that there was a huge market here for their video games. They felt the games offered something that wasn't on the market here. But they had a problem, and that was they don't have facilities in Europe. They don't have boots on the ground in Europe. They are an American company. And as you'll hear, they decided to enter into a license agreement. And the way a license agreement works is a company with contacts here in Europe enters into the agreement. It actually manufactures the games and the technology here per the specs that Intellex provides them. And it markets and promotes and sells those games and players, and then pays what's called a royalty to the owner of the technology, in this case, Intellex. These parties entered into a license agreement, and you'll have that agreement in evidence. But what Ms. Sheth didn't mention to you is Cranbrook didn't have boots on the ground in the continent of Europe either. As I mentioned, they're a British company, and what actually happened is interesting. Intellex selected 3 different companies to speak to about this license agreement. And Cranbrook was one of the 3, but they had been told about the opportunity by a consulting firm. And when Cranbrook told the consultant, we don't really have the capacity to do that, the consultant said, no problem, we have someone you can hire, and you can hold her out to be the expertise and the person with contacts to do the marketing. And that individual is Ms. Eve Rosenberg, and she's going to testify here. Ms. Sheth introduced her a minute or 2 ago. So you'll hear that right from the start, Intellex comes to the table thinking that Cranbrook has some roots in the continent of Europe and the ability to roll this technology and the games out across all of Europe, but in fact, they were a British concern and they had brought in somebody. It was like kabuki theater, except Intellex didn't know that. Well, it worked. Intellex chose Cranbrook to be the licensee. And as I mentioned, they entered into this license agreement. And I want to just show you a couple of the documents that are in evidence. This is a letter that was sent in the course of the negotiations to Ms. Rosenberg, who was handling this, the side of the deal for Cranbrook. And here you can see, and this will be discussed in the testimony, I'm sure, that there at the end it says, frankly, our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. If this is not the case, please notify us at once and we will seek a different licensee. And that was what lawyers call a material representation that Cranbrook had made. And the evidence will show that Cranbrook never spoke up and said, no, actually, we've just brought in this person and we're hoping to sink our hooks into the continent, but we really only have a British strategy, not a European strategy. So after the negotiations progressed, you can see here that Mr. Morganfield, our CEO, is writing to Willa Judson, and he says about this SP2 technology that it is specifically excluded from the deal. And so one of the claims that Cranbrook has in this case is that this new technology, SP2, should somehow be included in the agreement for Smart Plug. We'll prove to you that that's not the case, and we'll show you the language from the license agreement and the testimony of the witnesses as to their understanding. This is the license agreement. It'll be in evidence. And I can move quickly through this. There are several places in the license agreement where Intellex calls out how important it is that Cranbrook market their products in Europe, on the continent. They made crystal clear that Europe was critical to this venture. They even went so far as to list and define as a defined term all of the countries and other areas within Europe, and that's in paragraph 11 there. So things got started well because Ms. Rosenberg was there, and in fact she does have and did have good contacts in Europe. She speaks 3 or 4 languages. She was raised in Belgium, and she was the right person to do the job. But the first thing that she did, you'll hear, is she made a recommendation to her boss, to the CEO, Blair Nichols, saying we need to really roll up our sleeves and start marketing in Europe. So this is an internal memo that we got through a process called discovery, where Eve Rosenberg is writing to Blair Nichols now a couple of months after the license agreement about marketing Smart Plug. And you remember the correspondence in the negotiations, how important Europe is. Now that we have set up production for our Smart Plug license, I think that we should begin to pursue a marketing plan for sales on the continent. We are traditionally strong in the UK, but Intellex is depending on us to be equally strong in France, Belgium, Germany, Holland, Italy, and throughout the entire EU. Well, guess what? There's a further recommendation of 70% of the advertising budget to be a multilingual campaign on the continent. Well, Mr. Nichols said no. And you'll see here that he actually wrote it down. He sends a memo back to Ms. Rosenberg about the marketing proposal and says, I know that you're our marketing director, but I think it best to concentrate our efforts on the UK, at least for the first year or so. I don't mean to ignore the rest of the EU, but I think those markets will fall in line once we establish Smart Plug as the British standard. The British strategy has always been the key to our success. But we'll prove to you in this trial, ladies and gentlemen, that the British strategy wasn't what Intellex agreed to. And so as it comes before you seeking money from Intellex, Cranbrook has the burden of proving its claims, and we'll show that they didn't perform their side of the contract. And I'll just finish on this note. There is again, an internal document at Cranbrook, which is a summary of all of the sales And you can see here that in a number of countries, there were 0 sales. And these countries actually add up. If you look at the third column from the left, the population percentage of Europe, they add up to over 31% of the populated countries in Europe. There were 0 sales for 5 years by Cranbrook. So at the end of the case, I'll have an opportunity to come back to you and make closing argument, and at that time I'll ask you to return the only verdict that's supported by the evidence, and that is on behalf of Intelex and against Cranbrook. Thank you.
Thank you, Mr. Madison. Would the plaintiff call its first witness?
Thank you, Your Honor. The plaintiff calls Ms. Eve Rosenberg.
Before testifying, the witness would be placed under oath. The clerk of court would remind the witness that their testimony is subject to penalty of perjury. You may proceed, counsel.
Thank you, Your Honor. Ms. Rosenberg, could you please introduce yourself to the ladies and gentlemen of the jury?
Yeah, my name is Eve Rosenberg, and yeah, I'm from Brussels in Belgium.
Where do you currently work?
I'm currently the marketing director for Nederlander Chocolates. That's an international chocolate confectionery firm.
And can you tell us briefly about your educational background?
Well, I was educated at the London School of Economics, and I got my undergrad in marketing there with the highest honors.
And what's your employment background?
Well, I worked for Mondo Mundi and Kath Kinson, so both are top retailers who also sell online. So yeah, I'm kind of used to marketing and got the experience.
Are you familiar with a company called Cranbrook Industries?
Yes, I am.
And how do you know about that one?
I joined Cranbrook a few years ago for about 2 or 3 years.
And what kind of company is it?
It's a British company that is engaged in the sales and distribution of leisure products in UK, but also throughout Europe. It's a small family business, but really successful. And yeah, back at that time, I was approached by a headhunter because the CEO, Blair Nichols, was looking for somebody multilingual, also experienced in the European market. So he was looking for somebody representing his firm in Europe. So I initially started as a representative marketing assistant, but I was quickly promoted to be a European marketing director.
And who did you report to as the executive marketing director?
Oh, to the CEO, Blair Nichols.
Now, during the course of your work at Cranbrook, did you come into contact with a company called Intelex?
Yes, I did.
What kind of company was Intelex?
Well, Intelex is a very big US company that designs, develops, and markets video games and video game players.
Did there come a time when Cranbrook and Intelex contemplated entering into a contract?
Yes, that came.
And what
time.
was your role in that discussion?
Well, I was the lead negotiator on that deal.
And tell us about what kind of deal that was.
It was a license agreement between Intelex and Cranbrook. And under this agreement, Intelex licensed its called Smart Plug products to Cranbrook. And Cranbrook would then manufacture and also distribute and sell it in Europe. So yeah, in exchange for letting Cranbrook get this benefit, Cranbrook paid Intelex a royalty.
Now, did you have any discussions with the CEO, Blair Nichols, about negotiating this contract?
Well, I was basically in charge of this negotiation, but I think we spoke once or twice about it, but I honestly can't remember exactly.
Okay. Let me show you what has been admitted as Exhibit 4 in this case.
Yeah, I have got a hard copy here. Yeah, that's a copy of an email from Blair Nichols, so the CEO, to me, relating to the Intelex contract terms. It's dated March 19, 2013.
Okay, and if I could direct your attention to the second line of that email, can you tell us what it states there?
The second line, you seem to have already obtained an exclusive license to SmartPlug along with a quite reasonable royalty. The exclusive license is really the heart of the entire matter.
And what did you understand Mr. Nichols to mean when he wrote that the exclusive license is the heart of the entire matter?
Well, it was a huge deal for Cranbrook, so we really wanted, or it was very important for us to be assured that we will be the only ones selling and distributing this SmartPlug technology and that we could sell the latest technology.
And then Mr. Nichols writes, do be sure that we are protected for the extended term and that we have access to any modifications they introduce in America. What did you understand him to mean by that sentence?
So maybe the first part, this protected for the extended term. Yeah, I know that the parties agreed on a clause stating that each party can renew and also extend the contract after a 5-year term for another 5-year term. So yeah, it was basically also kind of a protection for us to cover the risk, and so we could see after 5 years how everything went and decide whether or not we want to go for another 5-year term.
And how about the second part of that sentence, that you have access to any modifications they, meaning Intellex, introduced in America?
Yeah, we wanted to make sure that we cover with this exclusive license all improvements, adjustments, modifications to this SmartPlug technology, so that we always be up to date and sell the latest technology for sure.
Now, in the next paragraph, he refers to something called a right of first refusal. Do you see that?
Yeah, requested a right of first refusal, yeah.
What is your understanding of what a right of first refusal is?
So my understanding is that in this exclusive license, we wanted to cover the SmartPlug technology and everything that's related to, but we also, in this right of first refusal, we wanted to cover every product that is unrelated to the SmartPlug technology. So it was basically also a protection for us in exchange for the high amount that we spent and invested for setting up this huge distribution system, and so we could take advantage of this, Intellect's research and development by this right of first refusal, because it was no automatism, but we could decide whether or not we want to promote another and distribute also another product and maybe amortize our cost with that.
And who was your counterpart at Intellex?
It was Mrs. Willa Judson.
And what, if any, discussions did you have with Ms. Judson about the exclusive license?
Well, for me, she seemed to think that we've already had this exclusive license to all products.
And in what context did that conversation come up?
It was in the context of the right of the first refusal, because she was like, hey, it's already covered by your exclusive license, but I wanted to make double sure that it's covered by the right of the first refusal, even if it could be part of the exclusive license.
Let me now show you what's been admitted as Exhibit 7.
Yeah.
Can you tell us what this document is?
This is a copy of a letter written by me to Mrs. Willa Johnson, and it's relating to the royalty terms.
And what were you conveying to Ms. Judson in this letter?
So basically, I wanted to make sure that in exchange for the higher royalties we agreed on, we wanted to make sure that we insist on this right of first refusal. So as I remember, we had a royalty offer of around 13.5%, but later on agreed on a higher royalty. So yeah, that was our exchange for that.
Now, in the last sentence, you write, if we are to carry the full cost of a continent-wide distribution and advertising network, then we must have the option of all future Intellex products, whether or not they are covered by our exclusive right to improvements on SmartPlug and its progeny. What did you mean by that?
I meant that with this exclusive right, not only the smart plug itself, so this microchip, but also the progeny, so everything that is related to this product, is covered by the exclusive right term.
Now, do you recall whether you got any response from Ms. Judson to your letter?
Yes, I definitely did, because we later on agreed on it.
Okay, let me now show you what's been marked as Exhibit 10.
Yeah. So that is a copy of a letter from Mrs. Willer-Judson relating to this right of first refusal, dated April 22nd.
And what does she write in her first sentence?
It looks like we have a deal.
And when she writes in her second sentence, whether or not the right of refusal adds anything to the exclusive rights to the smart plug system that we've been discussing all along, we fully expect Cranbrook to be our sole European distributor for at least a decade. What did you understand her to mean?
I mean that, or my understanding is that she thought that we are already the sole distributor also for not just the smart plug technology, but to every other product. So she was like, hey, yeah, even if it's not covered by that, yeah, you can have it on your right of first refusal. So yeah.
And then she writes, we look forward to seeing you market smart plug, or any plug, in quotes, or anything else for that matter. What did you understand her to mean by that?
Yeah, I remember that odd phrase because, yeah, for me that is pretty clear that we agreed on smart plug, any other plug, so related to the smart plug, but also anything else for that matter, so any other product which is going to be produced by them.
And during this time, what, if any, representations did she make to you about whether there were any other products that they were planning on marketing in Europe?
Oh, she didn't told me anything about other products. So I think, yeah, here it says, we do not anticipate introducing any other products in Europe.
Now, at any point during your discussions, did Ms. Judson or anyone else at Intellex mention anything about a SP2 product?
Not during this whole deal, no.
And how about anything about a Smart 2 product?
No.
Now, let me show you what's been admitted as Exhibit 62.
Yeah, that's the final contract signed on July 15, 2013, and it's signed by Willer-Judson and me. Yeah, and that's our final agreement.
Okay. And what were Intellex's responsibilities under this contract?
Intellect's responsibilities were to provide an exclusive license to manufacture, sell, and distribute the smart plug, but also to give this right of first refusal, as you can see in paragraph 1 and 9.
And what were Cranbrook's responsibilities under the contract?
Yeah, Cranbrook agrees to manufacture this smart plug, but also to use its best efforts to marketing it.
Okay. Now let's take a look at paragraph 1, which you referred to.
Yeah, Intellex agrees to grant Cranbrook an exclusive license to manufacture, sell, and distribute smart plug video games and game players in the UK and throughout Europe.
Now, if you look at paragraph 11b, is there a definition for smart plug?
Yeah, there is a definition of smart plug, but also smart plug products. As you can see, it's not just the microchip which is covered by this agreement, but also everything that is based on or designed to use in the smart plug microchip technology, extend to all modifications, revisions, and adjustments to the smart plug microchip.
Now, Why did you decide to include these modifications, revisions, adjustments, improvements to the definition of smart plug and smart plug products?
Cranbrook was not equipped to do his own research and development on the marketing side. So it's a small business, so we had to rely on Intellect's research and their development. And without this improvement clause, they could just like pull the rug out from under us as soon as there is a new innovation or improvement. So nobody would enter a contract without this term, because that would just be like suicidal.
Let me now go back to paragraph 1, which talked about the exclusive license. And actually, if we can go to paragraph 2, there we go. What was the term of the license?
Yeah, this license was granted for a period of 5 years.
And could you have the ability, or did you have the ability, to renew the license?
Yeah, the parties agreed to a renewal license. When you can see it in paragraph 7, so it says renewal of this agreement for a second 5-year term. Right.
And in paragraph 2, what was required in order for you to be able to renew the license? What did Cranbrook have to do?
Cranbrook, would actually use their best efforts to marketing and distributing this product. So perform, basically.
And let's go back to paragraph 2. How would you describe the level of Cranbrook's performance under paragraph 2?
I think Cranbrook did a good job. So it's not really required to have a whole system setting up, but we used this contract to do our best effort to set up this whole continental network and contribution system.
Now, you also talked about a right of first refusal. Let's take a look at paragraphs 9 and 10 of the contract, starting with 9. In paragraph 9, Intellect grants Cranbrook a right of first refusal. And what does that mean to you, a right of first refusal?
In my understanding, that's the point where all products are covered by this agreement, everything that is unrelated to the smart plug and is not part of this exclusive license.
And what does Intellex have to do in order to give you a right of first refusal?
So actually you have to read it together. So it's in paragraph 10, where we agreed how to make use of our right to first refusal. So Intellex should make it the opportunity to manufacture and distribute it available for Cranbrook if there is any new product, and if there is a new proposal to this new product, they have to give written notice, as you can see. In paragraph 10, shall be given written notice of the terms. So Cranbrook could react to another proposal.
And how long did Cranbrook have to accept the proposal?
30 days.
And the proposal, what is your understanding of what it means where it says within which to meet or exceed the terms of that proposal?
So basically it was an opportunity for Cranbrook to decide whether or not they want to distribute this new product or to exceed this proposal and give it to Intellex.
Mm-hmm. And by this proposal, are you referring to a proposal from another company?
Yes, yeah.
Now, why did you include these two provisions about the right of refusal in the contract?
Because we wanted to have the control to decide whether or not we want to take new technologies to our advertisement marketing system, and also because, it's technology, so what is new today could be really old-fashioned tomorrow, so we wanted to be up to date, because otherwise our whole distribution system wouldn't make any sense.
Now, does the contract, anywhere in this 2-page contract, does it require Cranbrook to have boots on the ground in Europe?
No. Actually, because when I heard about this Intellex, it's a big company, really, but they don't have any brand recognition in Europe. So every firm would have started it from the bottom. So, yeah.
And did the contract specify a time frame for which to achieve various sales targets in various countries?
No.
Now, did there come a point in time when you left Cranbrook?
Yes.
When was that?
It was approximately 8 months after we finalized this whole deal. So February 2015.
2014?
14? Oh yeah, 14, right.
And why did you leave Cranbrook?
Well, yeah, first of all, I thought I couldn't take this smart plug project any further, and the CEO, Blair Nichols, insisted on a UK strategy, so a marketing strategy. But because my parents were ill, I wanted to return to Belgium, and by returning to Belgium, I could combine taking care of my parents, but also, yeah, take further steps to my career.
And what do you mean when you say the CEO, Blair Nichols, insisted on a UK or British strategy?
Yeah, we had a discussion about how to advertise and market this smart plug. And I really had a vision to maybe do advertisement all over the continent. But he was really like, no, we have to concentrate on the UK, and that is fine. I mean, it's a different approach, and in marketing there are like, you can ask 10 people and they give you 100 opinions on how to advertise and marketing something.
And did this contract that you had with Intellex, did that specify any particular marketing approach?
No, it doesn't.
Now, did there come a point in time when you learned about the existence of the SP2 product?
Yes, there came a time.
How did you learn about it?
I read an article at the Games and Toys newspaper.
And what did it say in that newspaper about the SP2 product?
Yeah, it was like it was from the press that Intellex was about to enter into a contract with another company, I don't know, Contender or something like that, to license this SP2 this SP2 technology.
And what was your reaction upon reading that article?
I was concerned, surprised, maybe upset.
And why were you concerned, surprised, and maybe upset?
Because I knew that they weren't entitled to do that, because they weren't entitled to license this SP2 technology to another firm.
And what did you do when you read that article, or after you read the article?
Well, I know I wrote a letter to Blair Nichols.
And why did you do that?
Because, I don't know, I kind of felt responsible, because, I mean, I was the principal negotiator, and I knew that this was just wrong.
And why did you feel that it was wrong?
Because I basically knew like every syllabus of this agreement. I was part of the negotiation, and I mean, you can see the written words. It's pretty clear for me. So.
Now, did you receive a response to your letter to Mr. Nichols?
Yes, I did, but I think 4 months later. So, yeah.
So let me show you what's been marked as Exhibit 45.
Yeah, that is a copy of the letter I talked about. Yeah, it's from Blair Nichols to me relating to this testimony from January 22nd.
Okay. Now, at the bottom of that letter, he says, so he first apologizes to you, right, about the delay in responding, right? And what is he asking you to do in this letter?
He asked me to testify here.
Okay. Now, he also says, where is that? We need you to say the 2013 contract was intended to cover all, quote, improved home video game systems, not just modifications based on the smart plug technology. Did you modify your testimony today in any way to conform to that request?
No, of course not. And I didn't say those words because I think he got kind of confused because, just to clarify, this exclusive license covers the smart plug and covers also this related smart plug technology, but this right of first refusal covers the unrelated products.
And did you come here to testify voluntarily?
Yes.
And why did you come here all the way from Belgium to testify in this trial?
Well, I came all the way from Belgium to testify here in America because I can't stand business betrayals. So yeah, I think it's kind of David against Goliath, and intellects can't just swap business partners whenever they want to. So yeah, in my understanding, there is a contract written and pretty clear, and that's all that matters to me.
Okay. Thank you, Ms. Rosenberg. No further questions.
You're welcome.
Any cross-examination?
Yes, Your Honor. Well, there's another reason you have an interest in this lawsuit, isn't there?
Oh,
Ms.
yeah,
Rosenberg? And I don't believe you've told the jury about that additional reason, have you?
No, I didn't fully.
Would you like to tell them now?
Well, yeah. Well, I mean, I left Cranbrook, and part of my severance were stock options in Cranbrook.
So you own $160,000 of stock in Cranbrook.
Oh, that's right.
And you understand that Cranbrook hasn't been performing well of late, right?
Right, but
And your hope is that if Cranbrook can recover from intellects, the value of your stock will increase, or at least hold its value, notwithstanding Cranbrook's poor performance, right?
oh, I mean, it definitely could, but I stopped looking at my stock options because they just went up and down like every 5 minutes. So, but to clarify, I definitely can separate things, and I'm not here as a stockholder for Cranbrook. I'm here as the principal negotiator.
So I think you testified that Cranbrook was to use its best efforts to market Intellect's smart plug technology in Europe, correct?
Correct.
So let me show you an exhibit that's already in evidence. And do you recall this letter of March 4 to yourself from Willa Judson?
Yeah. Do you have it as a hard copy?
You can also see it in front
Oh,
of
yeah.
you.
I want to call your attention to the sentence there at the two sentences at the end of the paragraph that's expanded. It says, frankly, our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. If this is not the case, please notify us at once and we will seek a different licensee. So the first question is, you did make that representation that Ms. Judson refers to, didn't you?
Yes, I did. So, yeah, at that time, I mean, I was the lead negotiator, and I knew that there was interest in my person because of my educational background. And, I mean, we did everything we could. So I'm not part of this contract. So.
Well, I'm not sure what that means, but we're getting ahead of ourselves. When it says already capable of distribution all across Europe, you understood that what Intellects needed was someone that was ready to market and promote and sell its games all across Europe, correct?
Right, yeah.
And that wasn't true, was it, ma'am?
Oh, it was true. I mean, we focused on the UK marketing strategy because, I mean, Blair Nicholson, the CEO, wanted to concentrate on that, and it's also a question of liability, so he has the last, so his voice is actually louder than a marketing voice. But, so as you could see in your table, I think we also, we sold in France and Germany, so it's not that we didn't sell anything in Europe.
So I want to refer you to the agreement. It's Exhibit 62. And this is the licensing agreement that Cranbrook and Intellects entered into, correct?
Correct.
And there are, wouldn't you agree with me, there are numerous references to Europe and all of Europe in the licensing agreement, correct?
Yeah. It says best efforts to.
In fact,
throughout
in
Europe.
paragraph 4 here, the parties called out the United Kingdom and throughout Europe, correct?
Correct.
Now, the United Kingdom is part of Europe, at least I think today, as of today. And but you understood that Intellex was calling out the UK and the rest of Europe because that was important to them, right?
Yeah, I know that that was important to them, and yeah, we did our best effort to market that.
And as I understand your testimony, there is an exclusive license for smart plug technology, correct?
Correct.
And then a right of first refusal for any new leisure products, correct? Is that a yes?
Oh, yeah, sorry, yes.
So the parties knew how to say any new leisure product when they entered into this agreement, isn't that right?
Sorry, rephrase that.
That Cranbrook and Intellex knew how to say any new leisure product when they entered into this agreement. But the exclusive license that you're referring to did not include an exclusive license for any new leisure product, did it?
No, so the exclusive rights covered any improvement of the smart plug technology. That's correct.
And are you aware that the SB2 uses a completely different microchip from the smart plug microchip?
Well, kind of, yeah. Yeah?
Okay. Now, do you recall the parties calling out in this agreement a definition of Europe, which some might think is unnecessary or superfluous, but you knew, didn't you, that the reason this was called out in such detail was because it was so important to Intellex, right?
I mean, it was important for them to, well, get a foot on the ground here because they had no brand recognition at all. So yeah, I mean, they wanted to be recognized in Europe, sure, but it doesn't say, so this whole agreement doesn't say that we have to do advertisement in the whole, so on the whole continent, because that is business strategy or marketing strategy.
It says you have to use your best efforts throughout Europe. And you had in your mind an idea of what best efforts meant throughout Europe, didn't you?
Yeah, I mean, I had a vision that there can be, I don't know, advertisement in Italy and Portugal as well, but there are pretty small markets, so I get why we wanted to stop that maybe, because it costs a lot of money.
And by the way, am I correct that you were brought in by AMR Consulting to work for Cranbrook?
Yeah, they approached me.
And they were also the company that approached Cranbrook about possibly competing for the Intellex license, correct?
Correct, but I think Cranbrook was the one who approached the headhunter, so they approached me afterwards, yeah.
And you understood that your role was focused on Intellex and this license agreement if you could obtain it, correct?
Yeah, Cranbrook told me I quickly could be promoted to that, so to this European marketing assistant, no, a marketing director, because of that deal, yeah.
How much stock options does the marketing director get if you got 160,000?
I don't know, I guess that's what the marketing director gets, because I was it at that time.
Oh, you were, okay. And how long did you work at Cranbrook?
2 years.
Pardon?
2 years.
2 years. Now, in terms of these best efforts, you sent, and here are the signatures for the licensing agreement. You signed it on behalf of Cranbrook, and Ms. Judson signed it on behalf of Intellex, correct?
That's correct.
And you were authorized to enter into it, correct?
Yeah.
On behalf of Cranbrook. So in November, you sent a memo to Blair Nichols, and it was titled Marketing Smart Plug. Mm-hmm. And you certainly wouldn't be deceptive or dishonest in any internal memorandum, would you?
No, of course not.
You didn't know at this time that there would later be a dispute with Intellex about the license agreement, did you?
No, couldn't know.
So this was your attempt to lay out a plan that would comply with the best efforts clause, right?
Right.
And what you said is we should begin to pursue a marketing plan for sales on the continent. We are traditionally strong in the UK, but Intellex is depending on us to be equally strong in France, Belgium, Germany, Holland, and Italy, and throughout the entire EU. So you were describing what Intellex's understanding of this best efforts clause meant, weren't you?
Well, I was basically describing my opinion on how to sell and distribute things, but it's just my opinion. So I'm very like creative, modern, and I want to be at the youth market. And I thought that emphasizing this international character would make sense. But no, it would make sense, but it doesn't mean that it was a wrong decision.
So I want to try to advance the slide here. There's another paragraph in which you said, propose we devote at least 70% of our advertising budget to a multilingual campaign in those 5 countries within the first 3 years of our contract. That didn't happen, did it?
No, that didn't happen.
And again, that was your vision of what best efforts would be to promote in Europe, correct?
Yeah, just my opinion to that. Yeah. But the CEO is the one who's liable for that. So he has the last voice.
So finally, it says the key is to saturate the continent right from the start. Slow growth will most certainly result in no growth. And you said that because you knew that with video games, you need to get the kids or the players to buy the player, and then they'll continue to play. And if they choose another platform like Xbox or PlayStation, then you've lost them by and large, right?
It could be possible because, well, it was hard because Intellex, nobody knew Intellex and this whole smart plug technology in Europe at all. So we thought it is first the better step to concentrate on one market and then expand.
So how would the potential consumers in the other countries learn about Intellex if, as you say, they didn't know the brand and you didn't advertise it there?
Right, we didn't advertise it, that's true, but as you could see, there were sales in Germany and France as well, and it was 20%, so I guess that was not too bad for the first year.
So this is the memo in which Blair Nichols rejected your marketing proposal, correct?
Yeah, that's correct.
And the title is Your Marketing Proposal for Smart Plug. I know that you are our marketing director, but I think it best to concentrate our efforts on the UK, at least for the first year or so. I don't mean to ignore the rest of the EU, but I think those markets will fall in line once we establish Smart Plug as the British standard. So, in fact, he was ignoring the EU, wasn't he?
I wouldn't say he was ignoring it. It is just a different approach for me, in my understanding.
So for that first year or so, Cranbrook still had a requirement to use its best efforts throughout Europe, correct?
Well, yeah, but it's not saying that you have to expand it to Europe in any advertisement.
So tell us what best efforts were if you weren't advertising or promoting the product throughout Europe in that first year.
So I think the best effort is based on that decision to concentrate on the UK market because our CEO, Blair Nichols, decided that.
And somehow that would translate to sales in the rest of Europe? Was that the idea?
I guess that was his idea, yeah.
Well, it didn't work out that way, did it?
Well, I think it's overruled.
So I have to answer, yeah, it could have been better.
So I want to show you, we've just highlighted those, the British strategy. That was never anything you discussed with Intellex, right?
No, because
you didn't go back to them and say, hey, we're supposed to use best efforts throughout Europe, but we think it'd be better to use a British strategy.
Right, because I think we didn't negotiate the marketing strategy at all. Like really, if we concentrate on British or, so they didn't say, okay, you have to do advertisement in Italy, you have to do advertisement in Portugal, because those are actually also pretty small markets. So yeah, I don't know if that would have made sense.
Well, did you think back on all of the places in the licensing agreement that make crystal clear that all of Europe has to be included in the best efforts?
Well, it has to be the best efforts distributing it, yep, throughout Europe.
Okay.
But selling it throughout Europe, and that's what they did.
Now,
Counsel, I would suggest you move on.
Yes,
We're going to
I'm
keep on
just
schedule.
Wrapping up, Your Honor. In fact, you felt so strongly about this British strategy not being best efforts that you quit the company, didn't you?
Well, it wasn't just because of that. I was frustrated because it was my first big deal, So sure, everybody wants his opinion to be the one which is taken, but I get that that was my first big thing. So, no.
Well, what you said in the memo whereby you resigned was, and it's here before us in this exhibit, please accept this memo as my resignation effective March 1st, 2014. I've taken a position with Nederlander Chocolates of Belgium. I do not believe I can take the Smart Plug project any further given your insistence on a British strategy. So clearly, the British strategy, as it related to the best efforts that you personally had promised to Intellects to use, was a factor in your decision to actually leave the company, wasn't it?
I didn't promise anything, so it was Cranbrook, and they didn't promise this whole European strategy, so they just promised the best efforts, and it's in their scope to tell what's the best effort is. And just to clarify, my parents were ill, so I returned to Belgium.
And I am sorry about that, but you didn't mention that in your resignation memo, did you, ma'am?
Oh no, because it was addressed to the CEO, Blair Nichols. So.
But you did choose to address the fact that you didn't think you could help the Smart Plug project with the British strategy. Isn't that right?
As you said.
Nothing further, Your Honor.
Any redirect? Briefly.
Wasn't expecting to have that chance.
It's not mandatory.
All right. I think you were asked about the British strategy versus the European strategy. In your understanding of the British strategy, does it exclude any consideration of Europe?
Oh, no. It was just concentrating on it first.
And what's your understanding of why or how the British strategy was to be used to create sales in Europe?
It should have been, they wanted to use it as a start, so start with that market and then maybe expand, but that wasn't sure, so no.
Okay, no further questions.
All right. Thank you very much.
Yeah, thank you.
The plaintiff call its next witness, please.
Yes, Your Honor, we call the CEO, Mr. Blair Nichols. Good afternoon, Mr. Nichols. Could you please introduce yourself to the jury?
My name is Blair Nichols.
And what do you presently do for a living?
I'm the CEO of Cranbrook Industries.
And what kind of company is Cranbrook Industries?
It's a family business. It was founded by my grandfather in the Victorian age, and first it focused on toys, especially wooden toys, and after the war, the business expanded to more leisure time products such as fishing and hunting equipment or soccer equipment and cardboards.
Now, after receiving your MBA, did you start working at Cranbrook?
Yes.
And what was your objective for the company at the time?
Well, I wanted to bring Cranbrook to the 21st century, so I wanted to modernize our portfolio. And to me, it was clear that we need to include a video games and video game computers to our business.
And what did you do to ensure that Cranbrook was well positioned to enter the computer gaming industry?
Well, we are a small family business. We are in the toy sector, so we don't have any experience in the technology field. So we contacted AMR International, who are the leading business broker who got us in contact with Intellex.
And what kind of company is Intellex?
Intellex is a US-based computer game and computer manufacturer. Yes.
And what's your understanding of what Intellex was looking to do?
Well, they had a good presence in the US, but they didn't have any presence in the European Union. And my understanding was that they wanted to expand into the EU. And for us, it was like a win-win situation because we wanted to expand in the field of computer games.
And what, if any, discussions did you have with Intellex about their desire to expand into the European market?
Well, I was in contact with Intellex CEO, Ken Morganfield, and we were discussing more the generalities, but we didn't negotiate the details of the deal.
And who negotiated the details of the deal?
For our side, it was Yves Rosenberg.
And what's your understanding of Cranbrook's role in helping Intellex expand into the European market?
Well, as I said, we had a strong base, especially in the UK, and are a very well-known company for toys, and we thought it was like a win-win for us just to give Intellex the opportunity that we set up production facilities and distribute their technology.
And what, if any, directions did you give to Ms. Rosenberg in terms of how to negotiate this contract?
For us, it was a pretty bold move to go into the computer technology, of which we don't have any experience. And so my main objective was to protect our investment and to have a long-term investment. And so it was clear to me that we need an exclusive license. And that license should cover the then current smart plug technology, but should also cover all the improvements and modifications to it, because of course I knew that there are developments and improvements to the technology, and we always wanted to make sure that we always have access to the state-of-the-art Intellex technology, and that we don't stuck with the old technology.
And what, if any, guidance or discussion did you have with Ms. Rosenberg about the right of first refusal?
Well, again, I wanted to have this...
Irrelevant extrinsic evidence.
Overruled.
I wanted to have this deal bulletproof, and we had this clause that all improvements should be covered by the license deal, and in the event that it might not be covered, we wanted to have this right of first refusal just to get our hands on the technology and to have the opportunity to decide whether we want to have it for license or if we should just waive it.
Now, in any point during your discussions with Mr. Morganfield, did anyone from Intellex tell you about Intellex development of the SP2 product?
No, never.
And how about something called a Smart 2 product?
No, not either.
How did you learn about the launch of the SP2 product?
I learned about it by reading the trade journal.
Okay, and do you recall the name of the trade journal?
I think it was Games and Toys.
Let me show you what's been marked as Exhibit 15 in this case. 15, please. Thank you. Do you recognize this document?
Yes.
Now, based on this article, what did you understand about the SP2 product?
Well, as it is said in the second paragraph, Ken Morganfield himself says about the technology, it picks up and improves on the process that we began with Smart Plug. And even further in the next, or the last paragraph, I think Willard Judson says it, we have an excellent technical base in smart plug and we intend to build on it with SP2. So I thought it was an improvement or modification of the existing smart plug system, which gives us, yes.
And then just going to that, the second column of this document, it also says each machine will run all of the software intended for the other. The systems are designed to interlock so that none of our smart plug products will become obsolete. What did you understand that to mean?
Well, I thought that SP and SP2 are somehow interchangeable and are therefore like very similar technology.
And was this the first time that you heard about SP2?
Yes.
And what was your understanding of what Cranbrook's role would be with regard to SP2?
Well, I know we still had an agreement in place which had the clause that any improvement to the SP system will be covered by this agreement. So I thought we have at least. So my first understanding was that it should be covered under the improvement clause of the license agreement, but I knew at least it will be covered by the right of first refusal, and therefore I was pretty confident that we get the license for the SP2 as well.
And what did you do, or how did you communicate that, if at all, to Intellex?
I recall that I sent a congratulatory note to Ken Morganfield sometime in February 2015, so about 1 month after that I got aware of the new system.
Okay, let me show you what's been admitted as Exhibit 18 in this case. And what is this document?
Yes, this is the congratulate email that I sent to Ken, as I said. And and in this note, I congratulated Ken and Intellex on the development on the SP2, and expressly said that I looked forward to that day you licensed it to us for distribution in Europe.
And did you receive any response from Mr. Morganfield to your note?
No, I did not.
Now, did there come a time when Intellex wrote to you a letter purporting to offer you a right of first refusal?
Yes, they did.
And let me show you what's been marked as Exhibit 30. What's this document?
This is the letter you refer to, where Intellex wrote to us informing us that they had agreed a proposal with another company called Contendo, and that they informed us according to our existing agreement about that proposal, so that we have the opportunity to exercise our right of first refusal within the period of 30 days as agreed.
Okay, and what was your reaction to getting this letter?
Just one more thing, they at the same time offered to pay us $100,000 if we waive our right to the right of first refusal straight away. So they were still already pushing at this in this letter.
And did you agree to waive your right to the first refusal?
No, we expressly objected to that.
Mm-hmm. And what was your reaction when you got this letter? How did you feel?
Well, I was...
It's sustained. How he felt is irrelevant.
Well, were you surprised to get this letter?
I was surprised, indeed, especially as I feel a bit betrayed, because they obviously had negotiated a proposal with another company without disclosing this to us.
And let me show you what's been marked as Exhibit 28. Do you recognize this document?
Yes, this is the proposal that was attached to the letter.
And what was the name of the other company that they had negotiated with?
It was Contendo Gazelle. It was a Dutch company.
And what's your understanding of the terms of this proposal from Contendo?
Well, according to the proposal, it concerned the SP2 technology for which Intellex will grant Contendo an exclusive license. And they further agreed that Contendo will pay a royalty rate of 15%. And then, as a further obligation of Contendo, they have agreed to set up repair facilities in various European countries, especially in Hungary, Poland, and the Czech Republic. And for failure to do so, they agreed to liquidated damages amounting to $50,000 per month. After having read the proposal, I was a bit surprised, especially about the repair provision, because it's standard business practice. Such gaming computers aren't repaired nowadays. They are, if they are broken, they are replaced, but no one would invest the money to repair them.
Now, did there come a point in time when you accepted this proposal from Intellex?
Yes, we accepted it.
And now let me show you what's been marked as Exhibit 35. What is this document?
So this is the letter we wrote to Intellex in response to the proposal, in which we said that we are accepting the proposal and maybe it's a bit vague, but we also offered to even exceed the proposal in specific terms.
And in what way did you believe you were exceeding the proposal?
Well, first of all, with regard to the royalty rate, Contendo had offered a flat 15% royalty rate, whereas we have offered to match the 15%, and for some countries in Eastern Europe and Scandinavia, we offered an 18% royalty. Further, we offered to start production and distributing the SP2 system earlier. I think it was 2 months earlier than in the Contendo proposal.
So if you look at paragraph 2 that starts with additionally, what was the Contendo proposal with regard to a start date for production?
The start date for production in the Contendo proposal was the 1st of January 2017, whereas we offered to begin some of the distribution already in October 2016.
Okay. Now, with regard to the repair provision, what were you accepting as to repairs?
Well, we offered something equivalent because nobody maintains repair sites in various countries. So we offered to provide a service to the customers that they can ship in their devices by mail and get the repair done in that way, and not within several facilities in the respective countries, but in a centralized location in Germany.
Ah, okay. And did you address the liquidated damages provision?
No, I did not, because it didn't seem to be material to us in this regard. As you know, it was the liquidated damages amounted to $50,000 per month, which is in total for a year $600,000, which is in the computer gaming industries, which is a multi-billion industry. It's just peanuts. And even with regard to our license agreements with royalties in the excess of 25 million US dollars, I recall, it didn't seem material to us to address it in this point.
And what was the date, sorry to scroll back to the top, what was the date of your acceptance here?
We sent it on June 3rd, 2016.
And how did this compare to the 30-day period in which you were required to submit a response?
We were informed about the proposal on May 18th, so the deadline or the 30 days period would only expire on June 17, I guess.
Okay. And would it surprise you to learn if Contendo and Intellex had agreed that Contendo could use its offices in Poland, Hungary, and the Czech Republic as pick-up and drop-off points and actually mail the repairs into The Hague? Would that surprise you?
Yes, it's a surprise.
Was that included in the Contendo proposal we saw earlier?
No, it wasn't.
Did anyone tell you about such an agreement?
No, not until now.
What was Intellex's response to your June 3rd acceptance?
They rejected our acceptance, saying that our acceptance would constitute a counteroffer which does not match or exceed the proposal by Contendo, and therefore they declined it.
Okay, let me show you what's been marked as Exhibit 36. What's this document? Oh, I'm sorry.
Yes,
36.
this is...
Oh, I don't think we're there yet.
Okay.
Sorry, there we go, 36.
Okay. Yeah, this is the letter in which Intellex informed us that they consider our acceptance as a counteroffer, which they decline.
And what's the date of this letter?
It's June 18, 2016. So it was the last day of the period in which we could exercise our right of first refusal.
And what did you do in response to getting their June 18th letter?
Just to clarify, I immediately sent a fax to Intellex saying that our acceptance, what was meant to be an acceptance of the exact terms of the Contendo proposal, and that we had only alternatively proposed more favorable terms for Intellex, but this should never have been considered as a counteroffer.
And let me show you what has been admitted as Exhibit 38. What is this document?
This is the telefax that I have referred to just.
And why did you feel that you had to send this telefax reiterating your acceptance of their offer?
Because I had the impression that they misunderstood our acceptance, or rather they wanted to misunderstand it, and that they wanted to swindle us out of the contract.
And what was Intellex's response to this letter, this fax, excuse me?
Well, this fax was only sent on June 24th, and they just formally referred to it that it was untimely with regard to the deadline, and that they at this point had already been committed to Contendo.
Now, taking you back to the issue of the exclusive license, did there come a point in time when Intellex offered you an opportunity to renew the exclusive license for another period of 5 years?
They actually did. Even after all the dispute about the right of first refusal, they offered us to renew the license, but limited to Smart Plug 1, obviously.
And let me show you what's been marked as Exhibit 4. I'm sorry, Exhibit 48. And while we're bringing that up, did you accept their offer to renew the license?
Yes, we did accept it, because from a business point of view, it made sense, because we already had set up the facilities and sales were satisfactory, so not renewing it from an economical point wouldn't make any sense.
And if we can scroll down a little bit, you mentioned that this license, the renewal, would exclude SP2. Can you tell us what paragraph 3 is about?
Yeah, well, paragraph 3 is the provision where we are reflecting our disagreeing views, and that by this renewal of the agreement, no rights with regard to SP2 were waived or changed.
And was similar language included in the original licensing contract, excluding SP2?
I cannot recall.
Okay, we can show it to you. It's Exhibit 62. And if we can look at paragraph 1 of that document. Just a little bit lower. There we go. Does that refresh your recollection about whether SP2 was carved out of the original contract?
Objection, he didn't testify to a lack of recollection.
Sustained.
I thought he just said, I can't recall.
We'll have the record read back.
Okay.
I stand corrected. Overruled.
Does this refresh your recollection about whether the original agreement excluded SP2?
Well, when the original agreement was concluded, there was no reference to SP2.
Okay.
We're going to have to move along, counsel.
Yes, Your Honor. Just one more topic. You mentioned, what was your approach to marketing the Smart Plug product?
Well, as I said, we are a British company and we have a strong base in the UK. And my idea of best marketing efforts were just to start strong in our home base and then just to have the success bleeding over to the continent.
And why did you think that was a better approach than the approach recommended by your marketing officer, Ms. Rosenberg?
As I said, we have a strong base in the UK and a well-known company in the UK. And my approach was, if we get some critical market penetration in the UK, it might swap over to the continent as well.
And last question, what, if any, impact did the introduction of the SP2 product have on sales of the Smart Plug product?
It has intense impact on our sales, so they dropped significantly.
Okay, no further questions.
Thank you, counsel. Cross-examination.
May we have Exhibit 18, please? Exhibit 18. Now, this was an email that you wrote to Ken Morganfield, our CEO, when you found out about SP2, correct?
Yes, correct.
I believe you told us you found out about it from an article that you read in Games and Toys Weekly, correct?
Yes.
And you weren't trying to mislead Mr. Morganfield in this email, were you?
No.
You spoke from the heart, didn't you?
Yes.
You could have said anything you wanted in this email to him, couldn't you?
Probably.
And what you chose to say is, I congratulate you on the introduction of SP2. By all accounts, it is a technological breakthrough. Now, a technological breakthrough would not be a modification of smart plug technology, would it, sir?
Well, it was based on SP. I didn't have any insights in the technological details.
And then you went on to say, we expected something completely new from Intellects. Glad to see we weren't surprised. What you were saying there was, this is something completely new, right?
Apparently.
Is it, you're saying today, you were saying apparently? You were communicating that apparently it was something new?
Well, to the extent of my knowledge, what I had an insight, yes.
But you'll agree the email doesn't say apparently.
No, it does not.
And then it says, is it really a world away from Smart Plug? SP2 sounds like it will solve all of our European marketing problems. I look forward to the day that you license it to us for distribution in Europe. Now, you're here today representing to this court and this jury that you already have a license for SP2, aren't you, sir?
Yes, it's our position that the SP2 is an improvement within the contractual provisions of our agreement.
Pardon me, did you finish?
Yes.
If you already had a license for SP2, you wouldn't need to look forward to the day that Intellex would license it to you, would you?
Yes, but in the end, in my opinion, it was not so important if it's covered by the license or if we have hands on it by our right of first refusal.
Well, under the agreement, it has to be based on the smart plug technology to be covered by that license, correct?
That's correct. That's
And
the
then
language.
for the right of first refusal, that applies to any new leisure product. Isn't that right?
That's the correct distinction, yes.
And so SP2, if it were a new leisure product, Intellex would have to give you a right of first refusal. Isn't that right?
That's correct.
And that's exactly what they did, right?
Yes.
And you understand that's Intellex's position, if
Yes,
you
I
will.
understand it, yes.
So
but at the time where I wrote this email, I didn't have any insights with regard to the distinction of if it's a modification and it's based on the existing technology or not. So it's not that reliable as a proof for the construction now.
But you agree with me, sir, that this email is unambiguous in stating that Cranbrook had no rights with regard to SB2. Isn't that right?
Sustained. The document speaks for itself.
Yeah. So your testimony is that today you have a different position from the one you expressed in this email. Isn't that right?
Yes.
Whereas Intellex did provide you with a notice of first right of refusal on SB2. Isn't that right?
Yes, they did.
And instead of accepting it, you made a counteroffer, didn't you, sir?
Well, the language was a bit unclear, but it was intended to be an acceptance and at the same time offering some more favorable terms for Intellex.
But you understand changing the terms is a counteroffer, not an acceptance.
Well, we exceeded it.
I just want the witnesses' understanding.
Sustain. I'm going to sustain, move to strike the witness's answer.
So you're telling us that you added terms to the right of first refusal,
Yes.
terms that were not in what you understood the agreement between Intellex and Cranbrook, correct?
Yes.
Now, you could have simply said, we accept, and then try to negotiate those other terms later, couldn't you?
Yes, and that is exactly what I did with my telefax.
After
to
the-
clarify,
after-
it was always the same position, and this telefax clarifies it.
Well, are you telling us that the first thing you said in response to the right of first refusal was, we accept,
Well, it was meant to be acceptance.
but with additional terms?
Yeah, but the agreement says a right of first refusal can be exercised when offering exceeding terms. So
And the
there
reason-
can be a change in terms.
The reason that this was all such a concern is that Cranbrook was suffering financial losses at the time. Isn't that right?
That's correct.
And you didn't know if you could even perform this contract if you were able to enter into it, did you?
We would have done our best efforts to do it.
I understand, sir, but you didn't know whether or not you could perform it, did you?
I didn't know.
And if we can look at Exhibit 24 quickly. This is an internal memorandum from yourself to Tori Block, the operations and all senior staff. And you say in this memo, which is regarding video operations, I attach for your immediate review a summary of our operating results for 2014 and 2015. As you will see, although we have cut our losses in half, we have not achieved profitability. Our sales are inching upward at a consistent rate of 10% per annum, while indirect costs are falling by 10%. This is good, but not good enough if we are to maintain our contract with Intellex. So what you're referring to in that last sentence is the financial condition of Cranbrook, as you just told us, was threatening your ability to perform this contract. Isn't that right?
Yeah, correct.
Now, you've said, I think, several times that the British strategy was start selling in the UK and somehow it would, and I can't recall the verb you used, but
Bleed over.
Bleed over. And how would that happen, sir? Without advertising, without sales, without offering the product for purchase to the consumers throughout Europe.
Well, we did have sales outside the UK, and especially Intellex did never notified us that they were not satisfied with our performance.
Well, if we look at Exhibit 60, that's the summary over 5 years, year over year for Cranbrook, correct?
Yes.
Can we call up Exhibit 60, please? Exhibit 22 is the same document, I believe. And if we can scroll down, this essentially shows that for over 31% of the countries by population in Europe, there were 0 sales. Isn't that correct?
Yes.
Italy, some of the larger countries in Europe included, right? Italy, right?
Right.
In 5 years, you didn't sell a single video game in Italy.
Correct.
Let's move on, Counsel.
Yes, and the same in Spain, correct?
Correct.
And there's no reason to think that gamers in those countries wouldn't take to Smart Plug just like gamers have everywhere it is promoted, is there?
Yes.
Thank you. Nothing further.
Right. Very briefly.
Yes, Your Honor. Let me show you Exhibit 35 again. I think Counsel asked you about this one. Okay, if we can just scroll to the first paragraph. What did you write in that very first sentence?
I'm writing on behalf of Cranbrook Industries to exercise our right of first refusal with regard to the licensing of Intellex SP2 video products.
And then going to the very last sentence, if you could read that sentence as well.
We will be able to achieve this due to the fact that, unlike Contendo, we already have production and distribution facilities in operation.
Okay. So what were you intending to convey with this letter to Intellex?
We wanted to indicate that we are the better partner for this project, that we are already in place and prepared to set up production as soon as possible.
Now, at any point in time, well, let me ask you first, did you share your performance information with Intellex?
Yes, we did reporting to Intellex.
And at any point in time, did they tell you that they were not happy with your performance?
No, they did never.
Okay. Let me show you what's been marked as Exhibit 16.
We really are going to have to wrap up, Counsel.
Yes, Your Honor, last exhibit.
This is Exhibit 16?
Exhibit 16. Okay, now, can you tell us what this document is?
This is a letter by Willa Judson of Intellex to Games and Toys Weekly in response to the article by Games and Toys Weekly regarding the introduction of SP2. And in this context, Willa Judson especially addresses some points raised in the article, especially that the smart plug sales in Europe are slumping, which was stated in the article in Games and Toys. And in this In response to this, Willa Judson expressly said, "Our distributor, Cranbrook Industries, has done an outstanding job of getting the Intellect's message spread across Europe."
And you were copied on this letter, right?
Yes, and I was copied on this letter.
Okay, no further questions.
All right. Does the plaintiff rest?
Yes, Your Honor, the plaintiff rests.
You know, I think we're going to have to plow ahead. So, are there any witnesses the defense intends to call?
We do, but could we plead for a short comfort break, Your Honor?
Very short. 2 minutes. We'll proceed without you. You know, one of the jurors made the comment that wouldn't it be great if the jurors could ask questions? And actually, it's very rare, but there are some judges who will let jurors ask questions. Typically, they have to write it on a piece of paper and give it to the clerk and pass to the judge, and the judge decides whether, you know, the question is a worthwhile one or not, and will pose the question himself or herself. But so now you've heard the plaintiff's case. The plaintiff has rested, and now we will hear the defense case. Now, the plaintiff has the burden of proof. So at this point, the plaintiff should be ahead. But I think in this fact scenario, and you'll see this, I think, by the end of the case, and it's often true, a lot of the persuasive testimony comes out on cross-examination. So, I mean, I think the plaintiff's witnesses were subject to some pretty strong cross-examination. There were some documents there that they were stuck with, that they had to deal with in their testimony. But now we'll hear the defense case, and the plot will thicken. So, Mr. Madison, would call your first witness.
Yes, thank you, Your Honor. We call Willa Judson. Good afternoon, Ms. Judson.
Good afternoon.
You've been present during the testimony here so far.
Yes, I
so
was.
I'll try to move right along.
All right.
Can you tell us what your position at Intellex is?
Yes, I'm currently employed by Intellex. I'm their senior vice president and also their director of operations.
What role, if any, did you have in the formation of the license agreement with Cranbrook?
Back in 2013, I led the team that negotiated the license agreement.
Now, as you negotiated that license agreement, did you have certain objectives or directions in mind on behalf of Intellex?
Yes, we had objectives, yes.
Can you share those with us, please?
Yes, of course. Well, Intellex was very successful with the new technology smart plug in the US, and we thought we were ready to expand to Europe. And for this reason, we were looking for AIM partners who had the knowledge and the structure in Europe and could sell our products there.
So what did you do to try to accomplish those objectives?
Well, we are looking for foreign partners and discussed both terms of the agreement. And, well, we made clear that it was really important for us to adopt a Europe-wide strategy so that everyone in Europe could play our new product.
So there's evidence that the smart plug launched in the US in 2011, and the documents we've seen have indicated that the negotiations occurred in 2013. Is that correct?
That is correct.
And if you could tell us, please, why was it important to move quickly with regard to Europe and smart plug?
Well, it's, in the video gaming world, it's one of the basic principles. You have to be really fast and you have to be the first, otherwise you're out. And it is like those video players, if they have chosen one platform, they don't tend to switch often. So we wanted to make sure to get to Poland, to the Czech Republic, to Germany, and really to be the first before our competitors got to them.
And I hope this isn't a dumb question, but is there anything different about persons from different countries when it comes to their interest in video games? Speaking about Europe now.
Oh, maybe you're referring to we in the US, we like more action games and are more focused on them. And at that time, in 2013, 2013 in Europe, there were more those logical games, more cerebral, and we thought Europe was ready for our American-style games.
So the Americans were trying to dumb down Europe.
I wouldn't say that, no.
So, but within Europe, is there some difference between countries in terms of whether they would be attracted to smart plug or not that you discerned?
Well, we did not have the experience in Europe, so that's why we were looking for foreign partners who had those sophistication and knowledge. But I think we thought Europe as a whole, so that every country has the same, basically.
So if I could, I'll show Exhibit 9, I believe it is. It's a letter that's in evidence. And there's this statement toward the bottom, and it references a representation. It says, our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. You're the signatory on this letter, if I recall.
Yes.
And, excuse me.
Yes, sorry, I recognize the letter, yeah.
Was that representation made to you?
Yes, it was, and it was a material representation. We were counting on that. That was a main point.
Who made that representation?
It was my counterpart at Cranbrook. It was Ms. Eve Rosenberg.
Now, did you evaluate Ms. Rosenberg in terms of the suitability for the role that the licensee would play?
Yes, I made it crystal clear to her that it was of the utmost importance that the whole of Europe was covered, and yeah.
It says then, if this is not the case, please notify us at once and we will seek a different licensee. Yes. If Cranbrook had said, we really are not currently capable of promoting and marketing all across Europe, would Intellects have entered into this license agreement?
Objection. Calls for speculation.
Calls for speculation. Sustained.
Now, what was your impression of Ms. Rosenberg?
Oh, I was deeply impressed by Ms. Rosenberg. She had a lot of ties to the continent of Europe, spoke many languages, was highly educated, and she was very sure that you could make good sales with our product all across Europe.
And were you aware that she had been brought in especially to court Intellects for this license agreement?
Actually, I was not aware of this, no.
So I want to ask you, are you familiar with the license agreement itself?
Yes, I am.
And you negotiated that on behalf of Intellects, if I recall, correct?
That is correct.
So I actually want to go back one step quickly to a letter or memo from January 2013 to you from Mr. Morganfield. And it appears that he's giving you direction with regard to the negotiation of the license agreement. Do you recall this?
Yes, this was where I got assigned to negotiate the license agreement.
And in the first highlighted paragraph, he's talking about the slam bang game style has really taken off. And then in the second expanded paragraph, we have reached the point of talking price, and I would like you to take over the negotiations at this point. Was this the point at which you took over the negotiations?
Yes, correct. That was the point.
Now, at the bottom of the letter, there are some FYIs, and FYI 2 is highlighted here for the jury. It says, if you can close this deal, I will look very favorably upon your otherwise outrageous request for a 15% salary increase for the next fiscal year. If you don't close it, well, let's not even consider that possibility. Do you recall reading this from Mr. Morganfield?
I recall reading it, yes.
And what was he referring to?
Well, it was his reaction to my request for a long-earned salary raise. And he said he would link the closing of the deal with Cranbrook would positively influence his decision on my salary raise.
So did this motivate you in any way in terms of misleading anyone or deceiving anyone about the objectives?
Of course not. I just saw it as an incentive to do my job at the best of my abilities, and I would never let this statement by Ken Morganfield influence the way I conducted the negotiations with Cranbrook in any way.
So I want to move quickly forward now to the license agreement. This is the July 15, 2013 agreement. We've already seen at the end that you and Ms. Rosenberg signed on behalf of your respective companies, correct?
Correct, yes.
And there are many references that we've already seen to the importance of marketing in the United Kingdom and throughout Europe. And was that consistent with your negotiations with Ms. Rosenberg?
Yes, we just wanted to make it really, really clear that United Kingdom and the rest of Europe is covered, and yeah.
Now, I want to ask you about this paragraph 10, which is the right of first refusal paragraph. Can you tell us, perhaps in just plain English, what your understanding of that paragraph was?
Well, my understanding of that paragraph was that everything that is closely related to smart plug is covered by the license, but everything else we would have the option to seek a different licensee and to design specific requirements for manufacturing, distribution, and marketing for that new product that we might launch in the future. And maybe Cranbrook didn't have that requirements, and so we had the option to draw up a new agreement.
So we've heard about smart plug, and we've heard about this new technology, SP2. Smart plug was the subject of the exclusive license, correct?
Correct.
And then can you tell us, in your mind, where SP2 would fit, in the exclusive license or in the right of first refusal or somewhere else?
Clearly in the letter, so the right of first refusal, so it's not covered by the exclusive license.
And can you explain why you feel that way?
Well, SP2 is an innovation. In the gaming world of 2019, it's the big new thing, and in comparison to smart plug, it's a completely different product. It is a different microchip. It is covered by a different patent. It's using different materials, and it has different functions and features. In particular, it can play those logic games that we talked about, which smart plug cannot play at all. So it can't be an improvement or modification.
Now, we've heard evidence that Intellex did not inform Cranbrook of the SP2 research or development prior to it being announced publicly. Were you here for some of that testimony?
Yes, yeah, I was here.
This license agreement is in evidence. Is there anywhere that you can point us to where Intellex was somehow required to disclose its confidential intellectual property to Cranbrook?
No, there's no such thing in this agreement, and it would have been highly unusual to put it in there, I think.
So I'd like to move forward to the article that, well, we saw this memo internally with regard to the British strategy, and I take it you heard that testimony.
I've heard it.
Speaking of what was disclosed and what wasn't, did anyone at Cranbrook ever tell you that what their strategy was the British strategy?
No, I was not aware of any British strategy. I think we clearly agreed on a European-wide strategy, so I was quite shocked to hear that earlier.
Did anyone ever tell you that one of the reasons Ms. Rosenberg had resigned from Cranbrook related to the British strategy?
No, I was also not aware of this.
So I want to move to this Games and Toys weekly clipping from January 2015, and there's some testimony earlier about the comments that you made in the upper right-hand column there. I don't know if folks can see what I'm referring to, but you describe the practical relationship between smart plug and SP2. Were the statements that well, first, are these the statements that you made to the media at that time?
Yes, these were statements from me, yes.
And were those statements completely true at that time?
Yes, at that point of time, that was my understanding of our brand new technology. I wasn't completely fully into the topic in that moment, but yes, on that time, it was my understanding.
So in particular, are the systems designed to interlock?
Well, we didn't want our smart plug cartridges to go obsolete, so we ensured a backwards compatibility, but the SP2 products cannot, SP2 products cannot be played on smart plug. So afterwards, I learned, I understood that it wasn't all correct.
We've heard some questions about the performance of Cranbrook. Here's a letter that you wrote to the magazine, and I actually wanted to ask you about this statement. So the Weekly published the article that we just saw, and then you wrote a letter to them, and you made certain statements about taking issue with the story. And it seems like you're saying here that Cranbrook had done an outstanding job of getting the Intellex message spread across Europe. Do you recall writing this letter?
Yes, I do.
And were the statements made here the whole truth?
They were not the whole truth. They did not reflect our internal assessment of the performance by Intellex, unfortunately, by Cranbrook, unfortunately. But I chose these words to encourage Cranbrook to continue to do their job, which they did quite well in the UK. And I did not want to discourage them because we had an ongoing cooperation, and I did not want to broadcast that we have internal problems to the public. So.
There were also some questions about whether Intellex ever complained to Cranbrook about their performance. Do you recall hearing those questions and the answers earlier?
Yes, I do.
And to your mind or knowledge, is there any requirement that Intellex complain under the license agreement?
No, there's no such requirement.
So the best efforts requirement on the part of Cranbrook, does that apply irrespective of any complaints?
Yes, it does, yes.
Now, did you and Intellex actually see the results of Cranbrook's British strategy in Europe?
Yes, we saw the sales figures and were really disappointed because we did not understand why they had 0 sales in major countries like Italy and Poland and so on.
Did you think that perhaps Eve Rosenberg's leaving had anything to do with that?
Well, I can't be sure about that, but as she was one of the key factors in deciding to go with Cranbrook because she had the sophistication, the knowledge, the experience in European marketing, I think that might be a logical, yeah.
Can we wrap
Thank
it
you.
up?
Nothing further, Your Honor.
Okay.
Thank you.
Thank you.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Judson.
Good afternoon, Counsel.
Now, the CEO, Mr. Morgenfeld, asked you to handle the discussions with Cranbrook, right?
Yes, that is correct.
And that was your responsibility, right?
Well, yes, we were a team. There was also Steve Jeffrey and John Baker for marketing, research, and design. So, yeah.
But you were the lead negotiator on the contract.
That's correct, yes.
And Mr. Morgenfeld specifically told you that the license should cover SP2, right? I'm sorry, the license should carve out SP2.
Yeah, I think it wasn't called SP2. It was an idea in our thinking tank. It was, yeah, Smart 2, I think.
Smart 2. But he told you exclude Smart 2 from the scope of the license.
Yeah, yes, he did.
And he also told you it was essential that the contract preserve the option to negotiate a new deal if Smart 2 ever hit the market, right?
Yes, that's correct.
And he told you to make sure that Cranbrook understood that distinction, right?
That's also correct, yes.
But you didn't make that distinction clear to Cranbrook, did you?
To my understanding, I think it was quite clear in the contract because, like Smart 2, SP2 wasn't even a picture. It was about Smart Plug, the most sophisticated device right now on the market, and I think, yeah, that was quite clear.
But you didn't mention Smart 2, did you?
No, I did not.
And you didn't mention SP2 either.
No, no.
And in fact, you told Ms. Rosenberg that Intellex didn't anticipate introducing any other product in Europe.
That's correct, but that was my understanding of the time. It was, Ken told me they had an idea, but if that would come to fruition or not, that wasn't sure.
Well, Mr. Morgenfeld told you that Smart 2 was in development, right?
That's correct, but a lot of ideas are in development, and after a few periods of time and testings, we realized, okay, it's not the big deal that we thought it's going to be, so.
But he also told you that this new plug would knock the socks off of anything now in the market, didn't he?
That's his word, but he's always like he's a creative mind, and he uses sometimes those words.
Well, he also told you that this plug would dominate the worldwide market, didn't he?
He did, that's correct.
But you still didn't decide to mention it to Intellex.
Yes, but still we also have our trade and business secrets, and I don't think we were obliged to like say everything while negotiating the contract with Cranbrook.
But in fact, you specifically told Cranbrook there was no market. There was no product you were planning on introducing in the market.
That's correct, yes.
And nowhere in the agreement did you include a carve-out for SP2, did you?
That's also correct.
Now, let's show you Exhibit 15, which I believe Counsel showed to you.
Maybe if I could just interrupt to make a point. You may wonder, how does she know that she's going to answer this way to these questions, which were damaging? Because she's taken a deposition. She's deposed her before. She knows her testimony. So she's crafted her questions around the answers that she's already gotten in the deposition. So she has to give up these things. But go ahead.
So let's show you Exhibit 15. Now, this is an article in Games and Toys, right?
Right.
And you were interviewed in connection with this article.
That's correct, yes.
And you were quoted in this article, right?
Right.
And in the article says, all observers agree, I'm looking at the top of the second column, that SP2 chip is an outstanding modification of the smart plug technology. Do you see that there?
I can see it, yes.
And you also quoted a little bit later that Intellex had an excellent technical base in smart plug and that you intended to build on it with SP2, right?
That's correct. These are the words in the article, yeah.
And those are your quotations, your quotes.
Yes.
And you also noted that the relationship between the products was perfect.
That's correct.
Okay. Now, you wrote a letter to Games and Toys with one correction to this article, right?
That's correct. I think some time afterwards, not that long.
And you didn't correct the first statement about SP2 being an outstanding modification of smart plug, did you?
No, I did not in that time. I wish I had, but no.
But you didn't?
I didn't.
And the first time you're raising that this is something different is now, today in court.
Well, yes, internally we were clear about that. I was clear about that sooner, but yes.
And in the correction to this article, you also noted that Cranbrook had done an outstanding job.
Yes,
Right?
that's correct, yes.
Now, you had a motive to get this deal done, right?
Are you referring to the perspective of my salary increase? Or?
Right. If you got this deal done, the CEO would consider your request for a 15% raise, right?
That's right. That was his statement, but yeah, as I mentioned earlier, that didn't influence in any way the way I conducted the negotiations.
Well, you didn't tell Cranbrook about SP2, did you?
I did not, but that was because this was just an idea and not really into like anything that could come up as it on the table.
And instead, you misrepresented to Cranbrook that there was no product in development for Europe.
I don't misrepresent them. I negotiated about smart plug, the sophisticated device on the market, and not anything else. And I think the distinction was clear.
Well, you specifically told them that there was no product in development in Europe, for Europe.
Objection has been answered.
She can answer it.
Sorry, Counsel, can you repeat the question?
Sure. Did you specifically tell Cranbrook that there was no product on the market, no product in development for the market in Europe?
Yes, that's correct, but that was actually what I thought at that point of time.
Okay. Now, you didn't do any studies or anything to determine if Ms. Rosenberg's departure had any impact on sales or penetration figures in Europe, did you?
Studies, you might like performance assessment. No, I did not.
Okay. And isn't it true that you didn't care for the approach taken by Mr. Nichols with regard to the timing of marketing in the UK with the bleed-over effect in Europe?
Well, I think it was quite clear that we hit the European market, so the total European market, at once and initially. So I think the British strategy did really go away from what we agreed on. So,
well, in the agreement, did you specify anything about timing of launch in the UK versus timing of launch in Europe?
Well, I think the rollout on the whole continent of Europe was made really, really crystal clear in the agreement.
Did you specify that X sales had to be done in year one in Europe?
No, we did not specify numbers. That's correct.
And in fact, you just were you didn't want to use Cranbrook for SP2, did you?
No, sadly, unfortunately, we were disappointed by their performance, and we didn't want our new creation to be just created in the UK or distributed in the UK, but also that kids or young people from the Czech Republic could play our new games.
And so you talked with Mr. Morganfield about how to remove them from the rights that they had under the contract.
Remove them from the rights, that's not what I would say, but we were trying to find a distributor in Europe which could really focus on each country. That's correct.
And you didn't tell Cranbrook that you were having discussions with that other distributor, did you?
That's correct.
Okay, no further questions.
Okay. Next witness.
Call Ken Morganfield. Good afternoon, Mr. Morganfield.
Good afternoon, Counsel.
So were you here earlier when Mr. Nichols said that you were trying to swindle his company?
Yeah, I heard that.
And what is your reaction to that?
Well, that's totally not true. That's the only thing I can say about that.
Let me ask some specific questions. We've heard a lot about this smart plug technology. Can you, I understand you were the inventor and creator.
Yes, that is
true. Can you
true.
describe to us what it is?
Well, as mentioned before, American users or American kids tend to like action-orientated, quick working games, and that is what essentially Smart Plug does. Smart Plugs provide an unparalleled speed in the market and provides a unique gaming experience for those guys who like ego shooters or stuff like that.
When did you launch Smart Plug?
It was launched in 2011 in the US market.
And how did the market in the US react?
Well, just to be honest, we dominated it from the start. It was a really great success, one we are still very proud of.
So did there come a time when you thought about expanding the marketing and sales of Smart Plug beyond the US?
Sure, Counsel. After the great success we had in the US, we made up our minds, thought of expanding to Asia, but then we turned to Europe, and this was like in 2013, and we just went out and tried to find a European partner.
How did you go about that?
Well, it went pretty well, so we approached the Cranbrook then, a UK-based company, as being a partner for us, for the whole Europe, for the European market, to help us to provide our unique gaming experience also to the European users.
Who did you ultimately choose?
We chose Cranbrook, actually, as a partner because they promised us that they had the ability, or at least that's what we believed at this time, that they can market the product all across Europe, and that we can have this big success we also had all across the United States.
Now, at the time, did you authorize Ms. Judson to enter into the license agreement on behalf of Intellex?
That is correct, Counsel.
At that time, did you have in your mind what the best efforts would be of Cranbrook with regard to Europe?
Yes, of course. As I mentioned, we just want to have again the success, and we do not want to have it just in one country or one nation. We want to have it all over Europe, like in Germany, France, Poland, pick whatever you want. We would just want to penetrate the whole market in business terms. Yeah.
So we've seen evidence now that there were some financial troubles within Cranbrook. Did they inform you of that at the time?
I cannot recall of that, sir. Yeah.
So how would you assess Cranbrook's performance during the time that they were promoting and selling Smart Plug?
Unfortunately, I have to say they acted very poorly. They did not perform well. As Willa mentioned before, both of us, we were just like disappointed, personally disappointed, because Smart Plug was a great product, as it has been proven in the US, and just Cranbrook was not able to have the success and in Europe as we hoped when we asked them to help us.
So one question I have is, we heard evidence about a renewal of the license agreement with regard to SmartPlug and Cranbrook.
Yeah.
If you were unhappy with their performance, why did you renew?
It did well in the UK market, or not well, but at least it was satisfactory for us. And actually, being a businessman or being a salesman, normally we honor our obligations, and when we have a partner we think, okay, we could go with, we tend to do so, and because Cranbrook did okay in the UK, this was a reason for us to renew the contract.
So let me turn to SP2 and ask you, first of all, is that a product that you were involved in the development of?
Yes, sir.
And so can you tell us about how you came to develop it and what its attributes are?
Being a technology firm, so we're always on the look for new products, we always try new ideas, we always try different approaches. And during that time, we just developed a product which is known under the branch SmartPlug 2. And SmartPlug 2 that's the sole connection which it has with SmartPlug 1 is like the name, because it was already known in the market. But aside from that, it is like a unique technique, as Willa also mentioned, that it's protected by different patents and it's based on its own manufacturing process. And it's in addition to the unique gaming experience SmartPlug 1 provides, SmartPlug 2 also provides a unique gaming experience for cerebral games, which the European users tend to like more than just the action style we provided before.
You may have covered this, but is SmartPlug patented?
It is, yes.
And who holds those patents?
It's my company, sir. Yeah.
And then is SP2 patented?
Yes, sir.
And are those the same patents
No.
or different patents?
Actually not. As I mentioned, that are different technologies, and therefore it's like different patents also.
Do they use the same microchip?
No, sir. Yeah.
So there came a time, did there not, when you considered a license agreement for SP2?
Right.
And did you consider Cranbrook to be a realistic candidate for that?
Not at this time anymore.
And why is that?
Well, as I said, unfortunately, they did not perform well. Our main goal was the whole European market, and they acted poorly. They did not perform well. They were not successful. So on the second approach we took to the European market with our SP2, we wanted to be on the safe side, and Cranbrook was unfortunately not an option anymore at this point.
So who did you negotiate with?
Yeah, we just give this a thought, and who we actually can choose as a partner, and then it turns out to be Contendo. It's a Dutch firm, which we then license SP2 to.
And what's the geographic scope of that license?
It's the whole European continent, or the EU to be more exact. Yeah.
Now, we heard that there was discussion of taking products at some point to Poland and Hungary and the Czech Republic for
Yes.
repairs or shipment. Does Contendo have facilities in those countries?
They have, yes.
Does Cranbrook have facilities in those countries?
Unfortunately not, sir, no.
So we saw that the license agreement, if you need to refer to it, just tell me, but requires a right of first refusal to be extended to Cranbrook.
That is correct, yes.
If you were unhappy with their performance and felt that they weren't the best for SP2, why did you make a right of first refusal notice offer to them?
Because that's part of our philosophy. We believe in our contract, and they had the right for this first refusal, and that is because we offered it to them.
And did they accept that in your mind?
No, they did not.
Why not?
As far as I can recall, it was more like a counter-offer. So I think we made it pretty clear what Contendo's offer was. We sent it to them in a letter, and they just, I think as far as I can recall, they told us, okay, they do not have these offices or these facilities in Eastern Europe, and they were also not willing to accept the damages, the liquidated damages provisional we wanted in the contract.
And Well, strike that. Let me show Exhibit 35. I just want to make sure that we've taken a look at that. And I believe that's the response by Cranbrook to the notice of right of first refusal. So we can see it's on Cranbrook letterhead.
Yes.
Dated 3 June 2016. And do you recall whether that was timely or not within the 30 days?
I think this was, just when it comes to dates, this was timely. That is correct, yes.
So what was the problem with it?
Well, the problem was they did not meet all the terms which the offer of Contendo comprised.
Can you refer to the document and explain to us where? And if we can scroll down.
Exactly, so if I may lead your attention to the second paragraph, I start with, while we cannot guarantee to locate repair facilities in Poland, Hungary and the Czech Republic, this is, to be honest, one essential point we thought which was very important at this point, and they made it pretty clear just in the beginning of the letter that they're either not able or nor willing to provide this.
And whether one agrees with the wisdom of those terms or not, did you understand that that was a change in terms?
Yes, sir.
And were those terms, did you provide with Contendo that repairs that were needed would be accomplished by mailing the device to Germany?
Sorry, I'm afraid you have to repeat this question.
Well, let me do a better job. So there's a reference to making repairs available by mail from a central location in Germany.
Yes.
Is that in the Contendo agreement?
I can't recall, to be honest.
And there's a reference to Poland, Hungary, and the Czech Republic. Do you recall that in terms of the Contendo agreement?
Yes.
Now, did you understand that having a right of first refusal meant that you couldn't later amend or revise a contract that you entered into with Contendo?
I think those amendments would always be possible, but under the contract we had with Cranbrook, they should just accept the offer within the 30 days or leave it.
When the offer was outstanding and the 30 days hadn't run, did you have an intent as to if Cranbrook accepted what you would have to do?
No, sir.
Okay. And we've seen evidence of the lack of sales in countries like Spain, Italy, and others. Were those countries important to Intellex?
Yes, of course, because the whole idea of this Cranbrook contract was to offer our product all over Europe, because as you know, the market of Europe is interesting for us as a whole, because there's no need for us just to sell our product in England, for example. So of course we want to provide our gaming experience to all of the customers in Europe.
So you're the founder of Intellex?
I am. Counsel.
So did you hear the testimony of Mr. Nichols that if one sold and promoted the product in Britain, that perhaps it would bleed over to the continent?
Yes, yes.
Did you understand what he was talking about?
Actually not, sir, no.
Okay. Nothing further, Your Honor.
Thank you.
Cross-examination.
Thank you, Your Honor. All right, let's talk about the right of first refusal. You knew that Cranbrook had a right of first refusal under the contract, right?
Yes, Counsel.
And you were hoping they wouldn't exercise that right, weren't you?
At this point, we were hoping, that's true, yes.
And you even considered buying Cranbrook's option, right?
That is also correct, Counsel.
And you weren't optimistic that you would be successful in buying their right to exercise their first refusal.
Not totally, but in the interest of my company and my employees, I was giving it a try, yes.
And so you considered structuring a deal with Contendo in which Cranbrook would be unable to match that deal.
I wouldn't choose that word, but you may come to this impression, yes, is correct. Yeah.
Well, one way to do that was to place a premium on sales and services in Europe, right?
Mm-hmm.
And you knew that Contendo was strong in Europe, whereas Cranbrook did not have offices in certain European countries, right?
We knew it at this point, this is correct, Counsel.
Okay, and you were trying to structure the terms of the contract in a way that would make it hard for Cranbrook to accept.
We were trying to structure the terms of the contract in a way that we can have for sure success in Europe with our product.
Okay, let's take a look at Exhibit 26. All right, this is a letter that you wrote to Miss Judson, right?
This is correct, Counsel.
And in this letter, you wrote, more promising is the possibility of structuring CGNV's offer in such a way that
What
Cranbrook...
paragraph are we looking at?
I'm sorry, we are scrolling down
Scroll down a
to
little, yeah.
the fourth paragraph? Right.
Okay.
More promising is the possibility of structuring CGNV's offer in such a way that Cranbrook will be unable to match it. You wrote that, right?
That is correct, Counsel.
And CGNV is a reference to Contendo.
This is also correct.
Okay. Now, you felt so strongly about this that you decided to handle the discussions personally yourself.
As being the founder of the company, I feel a strong responsibility for my firm and my employees. That is correct. Yeah.
Right. Well, you weren't happy with how Miss Judson handled the prior discussions, right?
I wouldn't say it this way, but perhaps you can help me what you're referring to exactly.
Well, you told her at the end of this paragraph, you will not be involved. I will personally handle all of these negotiations.
Yes,
You wrote
this
that,
is
right?
Right. This is my responsibility as a CEO. This is correct.
Okay, but you let her handle the prior discussions about the exclusive license and the original contract.
That's correct, but we came to an agreement, me and Blair, beforehand, and she was, and her job was to discuss the details afterwards. That is correct.
Now, you went so far as to have discussions with Contendo about what services they could offer that Cranbrook would not be able to offer.
As I mentioned before, we are always looking for the best possibility for our company and our employees. That is correct.
Well, you worked with Contendo to structure the deal in a way that Cranbrook wouldn't be able to accept it, right?
I wouldn't choose these words. We would just try to make the best possible deal we can at this time.
Okay, well, let's take a look at Exhibit 27. Now, this is a letter that was written to you from Helmut Plotter, right?
That is correct.
And Helmut Plotter is the senior official at Contendo, correct?
This is correct, Counsel.
And he says, it looks like from the first sentence, following on our telephone conversation, it seems to us that we can offer several, quote, services that Cranbrook will not be able to match. He wrote that to you.
This is correct, Counsel.
And you had discussions with him about this, didn't you?
I expressed honestly my fears about having a further relationship with Cranbrook because, as I mentioned before, they acted so poorly beforehand.
And so you understood that Contendo's proposal would include the repair sites in Warsaw, Budapest, and Prague, right?
That is correct.
And you also suggested to Contendo that there should be a liquidated damages provision in the event they could not provide such repair sites.
This is correct, yes.
Now, Mr. Plotter informed you that they will likely use those 3 offices as drop-off and distribution sites, didn't he?
This is correct, yes.
And you didn't include that in the proposal that you sent to Cranbrook, did you?
I'm not entirely sure what exactly you're referring to, Counsel. Perhaps you have to help me there.
Sure, I'll help you with that proposal in a minute. Did you tell Cranbrook that Contendo's proposal contemplated using those 3 offices as drop-off and distribution sites?
No, this was not part of the formal business agreement we came to.
It was not in the formal business agreement,
As far
was
as
it?
I can recall, not, no.
Okay, but it was a separate side deal you had with Contendo.
I wouldn't call it a side deal. It was like normally we tend to have open relationships with our business partners, and I can't recall in detail how we came to that impression.
But you had that understanding with Contendo, didn't you?
Yeah, this is true, Counsel.
And you also understood that they would send the machines for repair to The Hague, right?
For this time being, I think this was what was planned, yes.
Okay, and you didn't tell that to Cranbrook either.
Our contract did not oblige us to do so, yeah.
Okay, well, your contract obliged you to tell Cranbrook about the written terms of any other proposal, didn't it?
This is correct, because this is, for my understanding, what is legally binding in the end.
Right, and so you did not include these in your written proposal with Contendo?
Not as far as I can recall, yes.
Okay, well, let's take a look at your written proposal with Contendo. That's Exhibit 28, if we could pull that up. Is this the written proposal with Contendo?
This is correct, Counsel.
Okay, now if you scroll to paragraph 4, that paragraph provides that Contendo will establish distribution and repair facilities for the SB2 products throughout Europe, specifically in Hungary, Poland, and the Czech Republic, doesn't it?
Yes.
And it doesn't say anything about these repair facilities actually being drop-off and distribution facilities, does it?
This is correct, yes.
And it doesn't say anything about the repairs actually being mailed into The Hague, does it?
No, neither.
And this is the proposal that you sent to Cranbrook for them to match or exceed.
Exactly, yes.
Okay. Now let's take a look at Cranbrook's response to your right of first refusal. If we could turn to Exhibit 35. Okay, and if we go to the middle paragraph, this is the counter proposal from, this is the proposal from Cranbrook to you, correct?
Correct, it's a counter offer, exactly.
And if you go to the second paragraph there, do you see Cranbrook is offering you 18% royalties in Eastern Europe and Scandinavia, right?
This is correct, yes.
And Contendo only offered you 15%, right?
This is also correct, Counsel.
And Cranbrook offered to expedite the production schedule to start in October of 2016, whereas Contendo offered January 2017. Isn't that right?
This is correct, but unfortunately I have to add at this point we lost the faith in our former business partner, or in our business partner. We didn't believe that they were able to fulfill those promises.
But this is what Mr. Nichols told you, right?
This is correct, Counsel.
This is his acceptance of your offer.
No, we considered a counter offer. I'm not sure on the legal terms there, but actually, of course, normally it would have been a reasonable deal. I know what you're trying to show, but we didn't believe that they were able to make these sales and to have this success which we needed, which we wanted, and which they knew right from the beginning we want them to have.
But in this proposal, you have two elements that are better, that exceed the proposals in Contendo, the provisions in Contendo's proposal.
On paper, yes.
And then the third provision, Mr. Nichols offers to make the repairs available by mail in a central location in Germany, correct?
Yes, correct.
And that is no different than what you actually had agreed to with Contendo to make the repairs at The Hague.
It was at this point very important for us to have this legally binding formal agreement.
A legally binding formal agreement for what?
As you can see from the offer from Contendo, that they were able to provide these repair facilities also in Eastern Europe. And from my understanding, Contendo was able to do so, and Cranbrook was not. And this was the important point for us at this time.
And it was so important to you, Mr. Morgenfeld, that when Contendo did not actually open up repair facilities in those three countries, did you do anything? You didn't do anything, did you?
This is correct, but the situation was different. Other than Cranbrook, Contendo exceeded our expectation. They did a very good job. We are very pleased. And as you know, you want to keep business relationships who are working well. And that is because we decided in the end not to press on this point, not to argue about these repair facilities.
So let me get this right. First, you decide with Contendo in this side deal to allow for repairs to happen by mail to the Hague.
This was an option at this time. This is correct,
right.
Yes.
And you didn't disclose that in your written terms of the proposal to Cranbrook.
Our contract did not make us to, right. Yeah.
Well, your contract required you to disclose the written terms of any other offer, didn't it?
This is my understanding, yes.
And you didn't do that?
If you want to put it this way, yes, Counsel.
And then, when Contendo failed to open up these offices, you didn't enforce the liquidated damages provision, did you?
This is right, but this was a different situation because Contendo did very well, exceeds every expectation, and we want to keep them as a partner. So there's no use in suing them or just to claim any money.
So it's okay for you to do that because you want to keep Contendo as a business partner.
Right, sir.
But you wanted to get rid of Cranbrook because they were a troublesome firm, right?
They did not fulfill the requirements. That is correct. They had a contract. They knew before what we wanted to do them, and they just did a poor job. And this is, in the end, business. As I mentioned before, I am responsible for my company and my employees. There are no presents which I can make to anybody. Yeah.
And you had already made up your mind that you were not going to that you were going to reject any proposal by Cranbrook, didn't you?
That is not correct, Counsel. We were totally willing to fulfill our contract with Cranbrook.
Well, you wrote a letter. Let's take a look at Exhibit 40. And this is a letter that you wrote to Mr. Plotter from Contendo, right?
This is correct, Counsel.
And you wrote, needless to say, we chose not to interpret their proposal as exceeding the terms of our offer.
This is correct, Counsel.
You wrote, needless to say.
Those were my words, yes, this is correct.
Okay. And you further wrote, thus we are now free of that troublesome firm.
This is also correct, Counsel.
Okay. And the offer that Mr. Nichols sent to you was dated June 4th, and that was within the 30-day period, right?
This is correct, yes.
Okay. And it's fair to say that as of today, Contendo has not opened up any repair facilities in the 3 countries in Eastern Europe.
Yes, but it's also correct to say that they exceed every expectation we had.
Okay. Now, at any point in time, you were provided Cranbrook's sales figures for the first 2 years of the contract, 2014 and 2015, right?
I think I just look at those with Willa in 2013 or 2014 as far as I can recall.
Okay.
Yeah.
And you never complained to Mr. Nichols about Cranbrook's performance, did you?
I can't recall, yes.
Okay. And instead you decided to renew that agreement?
No, we decided to do what's best for our company and our product, and we renewed the contract, as I said before, because we believe there was still a market, a tiny bit, which Cranbrook could do or could do business there.
Well, in order to renew the agreement, the Cranbrook's performance had to be satisfactory to you, right?
This is, yeah, we could call it that, I think, yes.
Well, that's what the contract says, isn't it?
I'm not quite sure about the language, but I think it was, yes.
Okay. And one of your direct reports described Cranbrook's performance as outstanding, isn't that right?
Cranbrook report, I can't recall it. Perhaps you have to help me there, which document exactly you are referring to.
Okay, no further questions.
Thank you, Counsel.
No questions.
All right, so that, the defense rests.
Yes, Your Honor.
So that is now the close of the evidence. Ladies and gentlemen of the jury, you have heard all the evidence. We will now hear the closing arguments of counsel. The counsel will tell you what they believe the evidence they've adduced has shown. So, counsel, Ms. Sheth, are you prepared to proceed with your closing?
Yes, Your Honor. And if we could just bring up the PowerPoint. So the evidence presented today tells us a compelling story of how Intellex broke its promise to Cranbrook. Today, you are going to be called upon to decide 3 issues. First, whether the SP2 product was a modification or an improvement of the Smart Plug product so that it was covered under the scope of the exclusive license. And second, whether Intellex offered Cranbrook its right of first refusal under the contract and whether Cranbrook effectively exercised that right of first refusal. And lastly, whether Cranbrook satisfied its obligations to use best efforts to market the Smart Plug product. Let's turn to the first issue. There is no dispute that the contract provided Cranbrook with an exclusive license. Sorry, do I just press the green button? There we go, okay. with an exclusive license to manufacture, sell, and distribute smart plug video games and game players in the United Kingdom and throughout Europe. Now, the question for you is, was SP2 included in that definition? So let's take a look at the licensing agreement. Paragraph 11B defines smart plug. I think we'll have to just go to the next one. The terms smart plug and smart plug products are defined in the agreement. And look at the three major characteristics of this definition. They are products that are based on the smart plug technology. They are products that are designed to be used with or otherwise exploit the smart plug technology. And lastly, all modifications, revisions, and improvements to the technology. Now, how do you know that the SP2 product is included within the definition of smart plug? Well, let's use common sense to start. What did Intellex decide to name this so-called new product? SP2. And in the beginning, Smart 2. Ask yourself, if SP2 was truly a new product, why did Intellex decide to call it Smart 2 initially and SP2 later? Why did they use the same initials and the same words as smart plug? Why did they refer to it as number 2? Isn't it more likely than not that SP2 means smart plug 2? And think about the iPhone. Is the iPhone 10 really a new product, or is it just an improvement on iPhone 9? Now let's look at the definition. How do you know that SP2 is included in the definition of smart plug? Let's look at how Intellex's own CEO and vice president described SP2. If we go to the next slide, we see quotes that both the CEO and the vice president of Intellex used to describe the SP2 product at the time. So look at the first quote. It picks up and improves upon the process that we began with smart plug. Look at the next quote. We've got an excellent technical base in smart plug, and we intend to build on it with SP2. That was from Ms. Judson. And then the last one, each of these machines will run all of the intended software for the other. These are key aspects of the definition of smart plug. They are products that are intended to be used together, they build on each other, and they improve on each other. Now, you might be wondering what to make of the fact that Intellex's CEO wanted to exclude the SP2 product from the scope of the license. And in fact, he specifically directed Ms. Judson to do so. But that may be true, but then look at what Ms. Judson did in response. Even though both her and the CEO knew that the SP2 product was being developed and that it had the potential to knock the socks off of anything in the market, and it was designed to be fast so that it could run both action games and cerebral games, neither of them breathed a word about it to Cranbrook. And instead, what did she do? She told them that the license was a broad license, that it covered smart plug, any plug, or anything else for that matter. And she also told them that they don't anticipate, that Intellex doesn't anticipate introducing any other products in Europe. This is not what was in fact the case. They were working on SP2, they knew that it had the potential to knock the socks off of anything in the market, and it had the potential for worldwide domination. Now, when it came time to finalize the contract, did Ms. Judson include an express carve-out for SP2? Take a look at the language of paragraph 1 and paragraph 11b. There is no mention of SP2, let alone a carve-out for SP2. But then contrast it with what we saw in the renewal agreement, where when they wanted to carve out SP2, they specifically said so, and they failed to do so in the original agreement. And you might ask yourself, well, why? Why didn't Ms. Judson include that language in the original agreement? Well, you had heard that she was promised by her CEO that he would consider her request for a 15% raise. And if she failed to close this deal, he wasn't going to consider her request at all. And so this discussion between Cranbrook and Intellex had been going on since March, And Miss Judson desperately wanted this deal to close so she could get her raise. And so what did she do? She remained silent about SP2. And by doing that, she was able to close the deal. Now let's take a look at the right of first refusal. Now, in addition to the exclusive license, Cranbrook also had a right of first refusal with regard to the manufacture and distribution in the UK and Europe of all new Intellex products. So even if, let's say, even if you buy their argument that SP2 is not covered by the exclusive license, you still need to determine whether Intellex broke its promise to Cranbrook to give it the first chance to make and sell SP2. Now, you know from the beginning that Intellex's CEO didn't want Cranbrook to market the SP2 product. And when that product was successfully launched in the United States and he wanted to expand it to Europe, he realized he had a problem. Under the contract, Cranbrook had a right of first refusal. And so what did he do? He worked together with Contendo to come up with a plan to deprive Cranbrook of this right of first refusal. And how do we know that he did this? Because he structured the proposal in a way that he knew Cranbrook would not be able to accept. And he didn't tell Cranbrook, as he was obligated to do, about the terms of the proposal. He hid an important part of the proposal, that the repairs could be mailed to The Hague. He left that out of the proposal entirely. And when he had these discussions with Contendo, Contendo suggested these repair sites in Warsaw, Budapest, and Prague, where it had offices, but it knew that Cranbrook did not. Contendo knew it could easily turn these offices into repair sites just by turning them around, but it knew that Cranbrook didn't even have sales offices, so the expense of creating these offices for Cranbrook would have been prohibitively expensive. And then Intellex's CEO suggested a liquidated damages provision in the event that these repair sites were not established. But that was not it. It's the secret side deal that makes this a very clear breach. The contract requires Intellex to provide in writing notice of the terms of any offer. And when they provided the Contendo proposal to Cranbrook to match or exceed, they left out these provisions. They left out that these so-called repair offices were actually drop-off and distribution points. And they left out that the repairs could be mailed to The Hague. And so what they proposed to Cranbrook was simply a sham. And despite all of that, Blair Nichols told you that Cranbrook effectively exercised its right of first refusal. It accepted the offer. It wrote to Intellex's CEO immediately on June 3rd, well before the expiration of the 30 days. It proposed an offer that exceeded the terms of Contendo's offer. First, it proposed a royalty of 18% in Eastern Europe and Scandinavia, and a royalty of 15% elsewhere in Europe. Meanwhile, Contendo had only offered 15% throughout Europe. It offered an earlier production date, October 1st, 2016, as compared to January 1, 2017. And look at the repair provision. The actual term of the Contendo proposal was that repairs were mailed to The Hague. And the actual term of Cranbrook's proposal was that repairs were mailed to Germany. That was the offer that met or exceeded the proposal of Contendo. Now, Intellex's lawyer will likely make a point about how the proposal was silent as to liquidated damages. But you know that liquidated damages were not important to Intellex. And how do you know that? Because when Contendo failed to open up those repair sites like it had promised, the liquidated damages were not enforced. And how else do you know that the proposal was a sham? Because Intellex waited until the last day, the end of the 30th day, to tell Cranbrook that its proposal was going to be rejected. And so when Mr. Nichols was surprised by that and said, no, we want to be clear, we're accepting your proposal, they told them that your proposal is untimely. They just found another excuse to get rid of the proposal and to get rid of what they viewed as a troublesome company. Ladies and gentlemen, I submit to you that after you consider the evidence submitted in this case, the only fair and just verdict that is one that holds Intellex accountable for the promises that it made to Cranbrook, the promise to provide an exclusive license for smart plug products, and the promise to provide Cranbrook with a right of first refusal for all other Intellex products. Thank you.
Thank you, counsel. The defense closing?
Yes, Your Honor. I want to thank you all very much for your time and attention today. It got a little warm in this room, and it wasn't all lawyer hot air. I think it was demonstrably warm. Cranbrook brought all of this on itself. And I want to walk through the evidence, but they harmed themselves, they harmed Intellex in the process. The truth is, they're fortunate we didn't sue them. And Mr. Morganfield has to sit here and listen to claims of swindling and shams and all the rest when the actual evidence is to the contrary. This is no good deed goes unpunished as to Intellex. First of all, for Cranbrook, even bidding for this was a stretch. Remember, we heard the testimony that they're a British toy company, 100+ years old. They're used to making children's toys, like the old days. This is modern technology that we're talking about here. So what they do is listening to this consultant, AMR, they bring in Eve Rosenberg and then hold themselves out through her as being a company that has, and you saw that in the documents, that has actual capability today. Cranbrook represented to Intellex that you are already capable of distribution all across Europe. If this is not the case, please notify us at once and we will seek a different licensee. That's fraud, ladies and gentlemen, for them to make that representation when they knew darn well they didn't have the capability. And I'm not blaming Eve Rosenberg because we saw what she does. She comes in and says, well, the contract that we negotiated says best efforts. I'm just going to scroll through here and then I'll come back to the agreement. She writes a memo to the CEO. She says, now that we have our set up production for smart plug license, we should begin to pursue a marketing plan for sales on the continent. That's what they promised they'd do. That's what best efforts is. But they don't come into this courtroom and say, we did all that, and now our side of the deal isn't being honored. And for good measure, she says 70%, at least 70% of our advertising budget in a multilingual, many languages, campaign in the 5 countries within the first 3 years. She understands perfectly what the representations were, why she was brought in, and what Cranbrook has to do if it's to perform under this contract. They're already strong in the UK. They need to get out there and market and promote throughout all of Europe. And sure enough, what does Mr. Nichols do? Again, bringing this harm on himself, he says, no, we're going to concentrate our efforts in the UK, at least for the first year or so. I don't mean to ignore the rest of the EU. What that means, by the way, is I'm ignoring the rest of the EU. But I think those markets will fall in line. So we have all these metaphors, bleed over, fall in line. Like what? How are, in these countries, how are the gamers going to even know about the products and be able to purchase them in a very competitive environment if we're not out there advertising them? It makes no sense at all. And then there's this British strategy that they keep secret. There are a lot of complaints. It's such an Anglo-centric view that we get in this case from Cranbrook, that the UK is the most important market and we're just going to ignore the rest. And whatever we do, the rest of the world will follow. Well, those days are done. And again, it's so meaningful that Eve Rosenberg is writing these things when she knows that there's no dispute, there's no lawsuit. She's telling the truth as to what's needed, what best efforts are. And Mr. Nichols is saying, no. So that's what they do. And of course, what does that end up getting us? The British strategy. Well, Eve Rosenberg resigns. And she mentioned a couple of times today that her parents were ill, and I take that at her word. But what she chooses to say in the resignation, and it makes all the sense in the world, is, I do not believe I can take the Smart Plug project any further, given your insistence on a British strategy. I.e., that's not best efforts. That's not going to succeed. That's not what we promised to do. And again, this is written at a time where there's no motive to sugarcoat or deceive or mislead or strategize or posture. She's speaking the truth here. She quits, goes back to Europe. And now where are we at Intellex? We've got a counterparty, Cranbrook, that's supposed to be rolling out a marketing campaign throughout all of Europe. And remember, in the agreement, we spell out exactly what that means, all the corners of the European Union, and they got nothing. And remember, we heard evidence that later Nichols writes to her and says, I need you to say that this was covered by the licensing agreement. And also, it's so odd for a company that's suffering financial losses. We saw that memo. Could we actually switch over to exhibit, I believe it's 24, and display that? While that's coming up, remember, that's the memo where Nichols says, we're losing money and we're not going to be able to keep our contract. In substance, we're not going to be able to keep our contract with Intellex at this rate. This is Blair Nichols. Remember, Tory Block operations and all senior staff in the company. This is like an all hands on deck, red alert. And here's the summary for 14 and 15. It's good, but not good enough if we are to maintain our contract with Intellex. So maybe he had his reasons, but again, he shouldn't put himself in this situation if that's the reality of it. And they come into this court and say, well, you never complained about our performance. Complained about zero sales in Italy and Spain and other countries. Over 30% of Europe is not even getting marketed with our product. We have to complain about that? I mean, that's emblematic of the whole problem. If you have to complain about zero sales, you've got the wrong licensee. So they didn't perform. And if they didn't perform, they can't come into court and try to hold us liable for some breach that didn't happen. But I want to address that head on. So we've got the license agreement. And the license agreement provides, as we heard, two separate things. It says, for any new leisure product, Cranbrook has a right of first refusal. And that's anything. And that's what some of our witnesses, our testimony was, yeah, they had this right of first refusal. So if they're prepared, ready, willing, and able to step up and match any offer, then sure enough, they'll get the new license for Cranbrook. And let me go to that language here. In the event that Intellex determines to manufacture, sell, or distribute in the United Kingdom and throughout Europe any such new leisure product. Now, this is very meaningful because what it shows is the parties knew how to make a contract about any new product. And if the exclusive license applied to any new product, they knew how to say that. It didn't. This is the right of first refusal for any new product. And I urge you to look at the definition of smart plug in the agreement. This is the definition of Europe. And I don't know that we have that in this graphic. Those are the signatures there. But it's clear that it's all tied to the smart plug technology. And we heard Mr. Morganfield, the inventor, the creator, the founder of the company, say it's different technology, different chip, different functions. Everything is different about it. Yeah, they use SP to take as much advantage of their brand as they can, but this SP2 doesn't meet the definition of the exclusive license that they already have. And you know what? Don't take my word for it. If we could see Exhibit 18 again, please. When Mr. Nichols first hears about it, he writes a congratulatory email to Mr. Morganfield, and we saw this earlier this afternoon. And remember, I asked him, you weren't trying to mislead anybody, you were speaking from the heart. Yep, it's technological breakthrough, completely new, a world away from smart plug. And I look forward to the day that you license it to us for distribution in Europe. That is perhaps the only candid thing that Mr. Nichols regrettably has said in this whole case. And he wrote it again at a time before there was litigation. He's basically saying we would have to compete for that license because it's not covered under the current license. And now he would have you believe that he already owns that license. And I would ask you to consider whether you can reconcile that position with that email that he wrote. Remember, that's him, not us. So that then leaves us with this right of first refusal. And boy, Mr. Morganfield has the patience of Job, because he very clearly could have just walked away from that and said, these guys aren't marketing, they're not selling, we got zero sales in all these big countries. He didn't even know about the financial troubles that they had, but he's a person of his word, and he extended the right of first refusal to them. And a right of first refusal where there's a 30-day limit, that isn't something you play around with. You say, accepted. And then if there are, and I love this, sort of better terms that you want to offer later or try to negotiate different terms and conditions, by all means, do it later. But you don't let that 30 days lapse by making counteroffers. And remember, we have evidence internally from Cranbrook in which they're talking about whether financially they can even afford to put themselves in this position. So, ladies and gentlemen, Cranbrook simply cannot sustain its burden of proof in this case. They've brought two claims for breach of contract, one for the license and one for the right of first refusal. And by the way, you can see, right, how those are completely inconsistent with one another. But if you listen to the law as His Honor instructs you and consider the evidence, the only reasonable common sense conclusion is that they are not entitled to any recovery for breach of contract. It's not part of the exclusive license. And by playing it too cute, they also did not accept the right of first refusal. And to boot, they didn't perform under the agreement, so they have no right to come into court and try to enforce it. Now, you will be given a verdict form. If we can go back to the display, thank you. The verdict form is very simple. Well, these are those statistics. By the way, did you notice down at the bottom, this is from Cranbrook's records, that these are the countries. See on the left, it says country. And they have Eastern Europe listed as a country. And they have Scandinavia listed as a country. Those aren't countries, those are regions. And here again, if your licensee makes those kinds of fundamental errors, well, it's not surprising that they've got so many zeros over on the far right. And Ms. Sheth is a fine attorney. I mean, if they had handled this as well as she handles it, we wouldn't be here.
That's enough, Counsel.
Okay. This is the verdict form, ladies and gentlemen. You should check no as to both questions. And then we can all get to an air-conditioned room. Thank you very much.
Thank you, Mr. Madison. Members of the jury, you have heard the evidence and the arguments of counsel. I will now instruct you as to the claims and defenses of each party and the law governing this case. You must arrive at your verdict by applying the law as I now instruct you, as to the facts as you find them to be. On July 15th, 2013, the plaintiff, Cranbrook Industries PLC, and the defendant, Intellex Electronics Inc., entered into a licensing agreement for the sale and distribution of smart plug video games in the United Kingdom and Europe. In 2012, Intellex entered into a contract with Nintendo Gazelle NV for the sale and distribution of SP2 video games in the United Kingdom and Europe. Both sides agree that these contracts existed. It is the terms of the contract between Cranbrook and Intellex that give rise to this dispute. Plaintiff Cranbrook Industries claims that it was contractually entitled to the licensing rights to the SP2 video game system, and that Intellex's arrangement with Nintendo Gazelle NV violated Cranbrook's contractual rights. Cranbrook asserts two grounds for this claim. First, it is Cranbrook's contention that SP2 video games are a modification or improvement of SmartPlug and are therefore covered under the contract between Cranbrook and Intellex of July 15, 2015. Second, Cranbrook also contends that the contract of July 15, 2015 gave Cranbrook a right of first refusal for the European licensing of any and all Intellex products, and that Cranbrook exercised this right by timely presenting the necessary writing to Intellex. Intellex denies that it breached the contract in any way. Intellex also denies that the SP2 is a modification or improvement of SmartPlug, and therefore denies that SP2 was covered by the contract of July 15, 2013. Intellex agrees that Cranbrook was entitled to a right of first refusal on the European distribution of all Intellex products, but claims that Cranbrook failed to effectively exercise that right in a timely fashion. In order to find that SP2 is a modification or improvement of SmartPlug, you must find that SP2 is the sort of advancement in technology or production of SmartPlug that was contemplated by Cranbrook and Intellex as a modification or improvement of SmartPlug when they entered into the contract of July 15, 2013. To find that Cranbrook effectively exercised its right of first refusal, you must find each of the following. A, that Cranbrook tendered to Intellex a written acceptance that met or exceeded the material terms of the proposed contract between Intellex and Nintendo Gazelle NV, and B, that Cranbrook's written acceptance did not constitute a counteroffer, and C, that Cranbrook tendered its written acceptance in a timely fashion. Intellex claims that Cranbrook had a contractual duty to use best efforts to market the SmartPlug video products in Europe as defined by the contract. Intellex claims that Cranbrook did not use best efforts and as a result breached the contract and was not legally entitled to exercise the right of refusal on SP2 products or to any renewal of the July 15, 2013 contract. If you find by a preponderance of the evidence that Cranbrook has established either of its claims, then your verdict should be for the plaintiff, Cranbrook Industries PLC, on those claims. If you find any of Cranbrook's claims are not supported by a preponderance of the evidence, then your verdict should be for the defendant, Intellex Electronics Incorporated, on those claims. So you've now heard all the evidence and the arguments of counsel. I've given you the law, which should guide your deliberations in reaching a verdict. Now, ordinarily, the jurors would be escorted into a jury deliberation room. A bailiff would actually be sworn to look over them and get them lunch or whatever. And the first thing they would do is go into a room and elect a foreperson, the person who would be in charge of communicating with the court if they had any questions. They would do that by passing notes out to the clerk. The jurors would have the ability, they would have all the exhibits, would go with them into deliberation room. They would also have these instructions on the law, and they could request of the court that any of the testimony be read back, because there would be a court reporter who would have taken an actual transcript of the testimony, and they could send a note out to the judge, you know, we'd like to hear the testimony of such and such witness and such time. We'd like to have that read back to us, and they'd come out into court, and that would be read to them. Whether the verdict has to be unanimous, how many jurors there are, whether you know, it can be less than unanimous, and if less than unanimous, how many jurors have to agree to reach a verdict, depends very much on jurisdiction to jurisdiction. For example, in California State Court, where I'm from, in the state court, it takes 9, there's 12 jurors, it takes 9 to reach a verdict. It doesn't have to be unanimous. In federal court, there's a minimum of 6 jurors, and it must be unanimous. So we don't really have the liberty and the ability and the time to have these folks who have been so attentive and listening to the witnesses and the evidence, to have them leave and deliberate and come back and return a verdict. So I'm going to suggest that we just go down the row here and hear each of your reactions, and if any of you have a disagreement or want to pipe up, we're very interested in hearing what you took away from this and, you know, what your leanings are. I will say that the deliberation process very often changes jurors' minds. You do find out, we get to talk to jurors afterwards, and we learn that they talk to each other, and in our experience, they take this job very seriously, and they will change their views as they deliberate and exchange views. So what we'll hear is kind of where you are now, and maybe, I'm sorry I don't know your names, if I could start with you, ma'am, on the end. Yeah, I can't read it, but.
The best always comes to the end. We can start on.
And we have a microphone there, and, you know, share us, you know, what's your thinking, you know, at this point? First off, you got a lot of information in a pretty short period of time. I know it's tough.
Well, I'm sure I got
absorb.
a lot of information, yes, and I'm kind of split it, but I'm a little, I don't know if I'm allowed to say that, but
yeah, go ahead. We want to hear
I
what you
tend
think.
more, I mean, if the technology really has nothing to do with both of them, doesn't matter if the name, if it's SP2 or Smart 2 or Smart 50, whatever, I don't think the name is really matters. Okay, they feel a little bit sad because they use their, you know, additional letters. I can understand them, but I can also understand this side. If it's absolutely the technology has absolutely nothing to do with each other, then I don't see a case of, you know, yeah, both sides did agree on stuff that they maybe not really got through with it, right? But maybe I would say if the technology has absolutely nothing to do with it, the profit on them, both of them agreed to still do business with each other, even if they're not really quite happy with each other, which I don't understand. If I'm not happy with something, I would not like to really work with them. You know what I mean? You know, why would you agree with somebody if you're not, you know, if you tell them you're a liar or you're, you know, I'm not trusting you. So I'd only do business if I trust somebody. I mean, this is what I learned, you know what I mean? And business partners should trust each other. And right. I think this is one of the main things.
It sounds like you don't think that that the new product was covered by the original license. Is that what I'm hearing? That it sounded to you from the evidence like it was really a different product and it isn't an improvement or whatever the other language was that would be covered by the original license.
I would say so. I mean, I'm not a technology specialist, whatever, but if both of them, he agreed that Mr.
We usually
Morgenfield told us.
It depends. You know, I've tried a number of cases in Silicon Valley, and, you know, they bring in 40 people originally that you pick the jurors from. And in San Jose, California, you'll have 10 or 12 engineers. You'll have several people who have patents themselves. You might have professors from Stanford University. In other words, some pretty sophisticated people called in for jury duty. But, you know, most of them will not have relevant, obviously won't have technical backgrounds or backgrounds in the particular business, which is the subject of the case.
Probably,
And how
yeah.
about the other half of it, right of first refusal? Do you think that that was properly exercised, or how do you feel about that?
I think both sides should have been a little bit more open to each other. But I mean, business is, if you see politics, nobody is honest. Everybody is lying, right? So, I mean, everybody tried to get their best way out of it. And I think, like I said, they couldn't be too bad for each other if they're still working with each other.
Right.
I mean, so...
But you know, you have to make a decision here.
I would...
Was the right of first refusal properly exercised, ma'am?
No.
No.
Well...
Okay.
Well, actually... Yeah, I was.
Yeah, okay. All right, good. But let's hear from the next gentleman.
Okay, well, I think SmartPlug and SP2 are pretty close together. It's an upgrade. I mean, from the obvious standpoint, it is pretty much the same name, and it is pretty close to each other. They are connected. They enable the use of the same games, of the same system, so it's clearly close to each other, in my opinion. I think the first refusal was fraudulent, in my opinion, as not everything was disclosed. I think when they termed it in a way that it was more suiting for the other contractor, that is, in my opinion, legal, but not disclosing the full deal was fraudulent. The third point that was made was about the marketing. That was not in the verdict in the end. But I think they clearly breached that when they only marketed for the UK and not for all of Europe, but that was not asked here, and I just wanted to add that.
So you thought, I mean, it sounds like you thought that Cranbrook actually didn't breach the contract and that they didn't perform the marketing that they were supposed to do. But,
yes.
But you think the right of first refusal was a sham, that was fraudulent.
Yes.
So you're with the plaintiff on that. And you also think that the products are close enough that the Smart Plug 2 would be part of the original license. So you're with the plaintiff on that as well.
Yes, I am.
Okay, so that's very interesting. We've got first juror is clearly a defense juror. You're a plaintiff juror, although, footnote, you're not happy with their marketing under the contract. Okay, interesting. How about the next gentleman?
First of all, thanks for the experience. It's my first time. And I think I just need more time.
You need more time?
Yeah, it's very difficult for me now.
You know, you realize all these other people that have been called in from their regular walk of life. They don't want to be here, your fellow jurors. They're here only because they got a notice in the mail that says they'll be fined $1,000 if they don't show up. And they all want to go home. They've all figured out what they're going to fix for dinner. And you want them to stay there while you make up your mind? They're not going to be happy with you.
Yeah. But I think my tendency is to defense.
You're kind of with the defense as well.
Yeah.
You agree with the first juror.
But I need to think about.
Right.
I need more time maybe, but
right.
Tendencies.
That's part of that's part of the beauty of the deliberative process, the jurors, the exchange of views, because there's so much information that comes in, so many documents, and people's minds wander. My mind wandered. Jurors' minds wander. Not everybody absorbs 100% of what they're hearing, but in the jury, they'll remember different things. And so part of the deliberation, some juror will say, but oh, don't you remember this witness said this? And everyone will say, oh, yeah, that's right, I remember that. And so a lot can come out of the deliberation process as jurors remember different things and bring different things to bear in their discussions. Okay, you're sort of leaning towards the defense, but you'd like to have some more time. All right, how about the next lady?
So I think that both sides had really good arguments, but I think both companies made some mistakes that led to this case here. So at first I thought that intellects probably chose the wrong business partners, and that they didn't knew beforehand, and now they're trying to get out of the contract somehow. And secondly, I think that Cranbrook, they didn't know what they loaded onto themselves. I don't know if they were equipped to, how to say, like, they were not prepared for this big task. And secondly, they didn't do a really good job in distributing the product throughout Europe. But the problem is that they didn't, so as I thought, they didn't have marketing strategy in the contract, and they didn't have like terms of fulfillment that they, or like requirements that should have been written down in the contract. So I think that Intellect has no grounds to say that they are a fraud because they didn't write it down. So right now I'm leaning towards Cranbrook, but I think this business relation is so good, so maybe they should
maybe there'll be another lawsuit.
Maybe, I don't know. So all boils down to the question if SP2 is something different than smart plug, and yeah, since the name is already the same, almost. And for me, I think SP2 is modification, and still, if it's different in the technology, although I think that the function is the same, so the product, the use of the product is the same. So for me, it's development from smart plug. So I think, I'm leaning towards Cranbrook.
And so you think that they probably didn't do a great job marketing, but the contract did not spell out, didn't establish a marketing standard. So you're not going to hold that against them.
Yeah, so the question is, did Cranbrook fulfill the contract, yes or no? And actually they did, because it does not specify how to or which strategy to go with in the marketing and everything. Yeah.
But it sounds to you as if the new product is close enough to the original product that you believe it was covered by the license.
Yes.
Okay. So you don't even have to get to the right of first refusal, but what would your view be on the right of first refusal?
My opinion on that one is also with Cranbrook, because when the article in this Toys and Something it was on January 19th, and the congrats email was on February 4th. So, and the proposal with the right of first refusal came on June 3rd. So it's a lot of time passed since the article came out, and I think they should have done it beforehand.
Right.
Yeah.
Remember what I said about jurors hear different things? It's really very interesting. All right, thank you. And the last gentleman.
Yes. Thank you. I think, to put it short, that the lack of communication led the two parties to this situation. On the one hand, we have Intellex for the technology side, the inventor. On the other hand side, we have the distributor, Cranbrook, and the technology thought just to develop something, but didn't get to or to make a clear decision with Cranbrook. They should have, Intellect should have talked to Cranbrook and said, we are not satisfied with the salaries in Europe, and we want to quit this contract, and we want to stop it and to look for a new one. But what did they do? They invent a new product which is very, very close to the SP1, and it's just an upgrade at my opinion. And they were looking for another company, the Condex, the Dutch company, and were making business with them without informing or not informing them early enough. They first should have informed them, hey, we have another one, I think they are better than you, come on. And also they offered them, Intellex offered Cranebrook $100,000 to get out of this. Yeah, this is for me an exhibit that they were not playing fair. Intellex didn't play fair with Cranebrook, and so I'm regarding to both questions, I'm for the plaintiff.
Okay. So that's interesting. You talk about not playing fair, and there is a concept of bad faith. I think there'll be German lawyers here who can talk about this, I'm sure, but I understand that in German contract law, there is a concept of bad faith in performance or bad faith in negotiation. I'm going to get this wrong. Contrahendo? Somebody help me out here. Am I making any sense at all? And it sounds like you're kind of reacting to what you see as bad faith behavior on the part of the parties.
Yes.
In other words, in a very Germanic way.
Yeah,
Which is fine.
I believe I'm not convinced by the defendant, because also we have the article and where they say, well, now we have the SP1, SP, and then now it's based on SP2 is based on SP1, and so on. And for the official side, they say, yeah, that's the same product more or less. Right. It's just it's like iPhone 9 or iPhone whatever and iPhone 10, yeah. And they should have, if they are and also we have. It's not convincing me if I don't know the lady from Cranebrook wrote to him. From Intellex wrote to the editor, Cranebrook did a good job, a great
right, you
job.
Heard that. That went by very fast, but you picked that up.
Yeah. That's what they say. And I say, hey, okay, after this, now she's saying, I didn't want to encourage. Right. I did want to encourage them and so on. And
that's the power. That's the power of the jury, of many listeners, and then deliberating. So they've told us what their initial reactions are. I don't know how they would come out if they deliberated. I think our first juror here at the end might. You strike me, ma'am, and I mean this in a good sense, as a strong personality, and she might have turned out to be the foreperson, and. Forepersons have a way of kind of bringing things around to their way of thinking. So I don't know if you all had a right to deliberate whether the outcome would be the same, I'm sure some of your views would change as a result of deliberation. I mean, in this case, there was obviously evidence on both sides. Both sides had points to make, but that's always true of cases that go to trial. It's only the close cases go to trial. The other ones where one is clearly right, they fall off the system one way or another. They get dismissed or summary judgment is granted, or those cases settle because we have this discovery process and everybody it's like you're playing a card game and you get to see the other side's cards and you can size up what the chances are of what's going to happen in trial, and a lot of cases get settled. This would be kind of typical of a case that would go to trial in that there are good facts and bad facts on both sides. It's the way it always is. Well, thanks very much. We enjoyed doing this. I'd particularly like to thank our very patient jurors, and thank you. And the witnesses who worked with us were fantastic. Thank you so much. And thank all of you for attending.